Yeah.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಗೆ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು
Your Honor, office number 56. Last 3 hearing dates, office number was not called, and it's been.
give a fresh matters. Fresh matters, you kindly please.
Patent operation.
Fresh matters, and wherever you given application for early hearing, those most. Fresh matter. Sir, give it, sir. Please give it. fresh matters, and wherever you have already filed application for early hearing, those memos you can give.
One submission, my lord. In this case, my lord, the petitioners are claiming the compensation on my land, my lord. I am not being a necessary party. Therefore, my lord,
Application ಕೊಡಿ, application ಹಾಕಿದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ fresh matter ಆದ್ರೆ ಕೊಡಿ, ಎರಡು ಬಿಟ್ರೆ ಯಾವ್ದು ಬರೋದಿಲ್ಲ. ಹಾ? ಹಾ. ಕೊಡಿ ಕೊಡಿ. Please give it.
The deputy director of fisheries, my lord, he has allotted the.
Please call out the matters.
Submission, Your Honor. Serial number 32.
Please call out the matters. Yes. Serial number 1. Serial
In
number
this case, I
1.
am for the petitioner, my lord.
Yes.
My lord, I am seeking a certiorari quashing order dated 21/3/2023 passed by the Chief Judicial Magistrate, my lord. My lord, the petitioner who is the
Yes.
Like, my lords, I appear for the respondent, my lords. I've just received instructions, my lords. May I please seek for a week's time, my lords?
my lord, till the time, my lord, stay may be granted, my lord. There is they are taking position, my lord. They are third parties to the transaction, my lord.
My lords, I'll have to seek information as to
Literally,
what is the
I am the
outstanding-
bona fide purchaser of the
Madam,
flat.
after filing caveat petition, how can you make
My
the
lords,
submission?
No, I'm not.
Please
I
wait.
apologize.
Please wait. Yes.
My lord, in this
Yes,
case,
Learned Counsel.
I'm a bona fide purchaser of the flat, my lord. The respondent number 2, the respondent number 8, my lord, they already given NOC to the buyer to purchase the flat. After that, I'm taking loan from the bank, my lord. I'm paying EMI. Now they are proceeding as a surfacing, my lord. They are trying to take
Against
my
whom?
position, my lord.
They are proceeding
Against,
against whom?
Against the builder, my lord. But the flat is mine, my lord. Flat number, my lord, B1-107, my lord. Kindly peruse annexure F, my lord. Who is Anand Reddy and Venkatram Reddy, who are the builders, my lord.
I think similar matters had come up, isn't it?
Yes, my lord. Yes, my lord. There is a 22 matters before this honorable court, my lord. Already some of the
Edelweiss. Which is that other
Edelweiss,
matter
madam.
where? Which is that other matter?
My lord? Yes, my
Which is
lord.
that other matter where I have passed orders, interim orders?
Yeah, yes, my lord. I'll confirm, my lord.
ಯಾವ್ದಪ್ಪ? Which is that other writ petition where I have passed orders?
Sumi, one ನಿಮಿಷ Sumi, ಹೇಳ್ತಿದ್ದೀನಿ. My lord, kindly pass over the matter, my lord.
Edelweiss ಅಂದ್ಬಿಟ್ಟು EDELWEISS Edelweiss Asset Reconstruction Company Limited. ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್. We have passed orders. ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಿ.
Serial number
Pass
2
over.
also same connected matter, my lord.
Pass over. ಚೆಕ್ ಮಾಡಿ.
Number 2.
Yeah, two same.
Same
Pass
connected
over.
matter, my lord.
Number 3. India.
Yes.
We have given NOC.
Huh?
We have given NOC. For petitioner, we have given NOC.
You given NOC. Huh?
The other advocate has to appear. Madam.
We are not going to take that kind of a submission from you unless the parties appear or alternative arrangement is made. We will not permit you to retire from the matter. Pass over.
Petitioner stood as a guarantor to the fourth respondent. And an award was passed against the fourth respondent.
Huh.
Auction is also that as per annexure A and B, It was scheduled to be held in the month of May 2023. But they did not take, auction the property. Now, my lord, an order based on the decree, my salary has been attached. As per annexure G, page number 21. My lord, this order has been passed based on annexure E, my lord, which is an notification dated 3/3/2022, wherein the Konkan Railway Corporation Limited has taken a issued a notification saying that the people who are standard
Loans availed from financial institutions, banks, cooperative societies, deduction of salary for remittance towards outstanding dues.
This is of the year 2022.
If there's a case against you,
That was in the year 2015. My lord. I stood as a guarantor in the year 2015. But there is sufficient money or property to recover from the fourth respondent. But bank is not taking
what
it.
is the purpose of your standing as a guarantor?
There are 3 guarantors, my lord. 3 guarantors. My lord, I have already taken loan, my lord. I have been paying 50,000 rupees as loan installment. My loan will
Sir,
become
the liability is
equal.
jointly.
Yes, my lord, joint and several.
Yes.
My lord, but one thing is that now there is sufficient secured asset of the.
Barla, you can't say you proceed against the borrower. Then what is the effect of your standing as a guarantor then? Why did you stand as a guarantor?
First, let them.
ಹಂಗ್ ಬರೋದಿಲ್ಲ. ಆ ತರ
Salary, my
there is
lord.
no such law which says, no, you first proceed against the borrower. If then it is not recovered, then you proceed against the guarantor. ಆ ತರ ಇಲ್ಲ ಕಾನೂನು.
ಇದರಲ್ಲಿ annexure E, which is passed in the year 2000. My lord,
Takes notice for respondent number 1.
may I make one submission.
And
2022, the notification.
Issue emergent notice to response number 3 and 4.
3 and 4. But
3, 4 and 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures in the learned ABA.
my lord, till next date of hearing, my lord, there can be.
No, sir.
My lord, the reason, my lord, I am
No, sir.
telling, it is in the notification issued in the year 2022. My guarantee was in the year 2015. The
It
notice,
is not because of the notification, sir. That is the law.
that is.
Yes.
my lord.
Next matter, please.
Sorry, till the next date of hearing, my salary.
No, sir.
Archaka Sri Pullur Mukambe temple.
Huh?
What happened? The 6th respondent. He said this one petition to the executive officer of the temple. Annexure B. That is, I typed copy is page 24. That he has producing the general power of attorney of his family members. His grandfather was the Archaka. He may kindly be permitted to allow the perform the puja. Copy of the GPA is annexure C. And annexure D, my lord, page 31. The resolution of the board. Nirnaya. Annexure B, page 31, my lord. Board resolution. Lordship got it.
Annexure B is given by whom?
Annexure B, 6th respondent has given this one petition to the executive officer of the temple. Stating that my grandfather was performing puja, I may kindly be allowed to perform puja. Typed copy of producer. And he has also enclosed a GPA given by other members of his family. They allowed him to perform puja. He was not an Archaka of the temple. And based on that, as per annexure D, board passed a resolution, page 31, annexure D.
Yes.
That ನಿರ್ಣಯ ದಿನಾಂಕ 30/12/2017 ನಡೆದ ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿ ಸಭೆಯ ನಿರ್ಣಯದಲ್ಲಿ ಸಂಖ್ಯೆ ನಂಬರ್ ರಾಮಚಂದ್ರ ಅಡಿಗ ಸಣ್ಣ ರಾಧಾಕೃಷ್ಣ ಅಡಿಗ ಇವರ ಪೂಜಾ ಸಮಿತಿಯು ದಿನಾಂಕ 18/3/2018 ಪ್ರಾರಂಭಿಸುವ ಬಗ್ಗೆ ಅನುಮತಿಗಾಗಿ ಮಾನ್ಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಯಾವುದೇ ನಿರ್ದೇಶನ ಬಾರದೇ ಇರುವುದರಿಂದ ದಿನಾಂಕ 18/3/2018 ಸದರಿಯವರ ಕುಟುಂಬ ಪೂಜಾ ಸಮಿತಿಯನ್ನು ರಾಮಚಂದ್ರ ಅಡಿಗರಿಗೆ ನಿರ್ವಹಿಸಿಕೊಂಡು ಬರುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರ ಆದೇಶದ ನಿರೀಕ್ಷೆಯ ಮೇಲೆ ತಾತ್ಕಾಲಿಕವಾಗಿ. That means in anticipation of approval of the commissioner. And then 5th respondent also he has given a power of attorney, general power of attorney, K. Prabhakar Rediga and family members, that he says, page, you will also kindly page 33, my lord, the third para, page 33, my lord. We are presently employed and keep traveling out of Bangalore in connection with my official work, and as such we are busy. he is also not Archaka, but his father was Archaka, he died, none of them represented. Then he says, yeah, I have given a joint power of attorney. And what happened? Now the government also issued a circular, Annexure F, page 39, madam. Annexure F, madam.
Yes.
That after the color that ಆದರೆ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿ ಒಳಪಡುವ ಹಲವಾರು ದೇವಾಲಯಗಳಲ್ಲಿ ಅರ್ಚಕರು ತಾವು ಬೇರೊಂದು ಉದ್ಯೋಗದಲ್ಲಿದ್ದು ತಮ್ಮ ಸರದಿ ಪೂಜಾ ವೃತ್ತಿ ಅನಿರ್ದಿಷ್ಟ ಅವಧಿಗೆ ಇತರ ವ್ಯಕ್ತಿಗಳಿಗೆ ನೀಡಿ ಪೂಜಾ ವೃತ್ತಿಯನ್ನು ಪರಭಾರೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿರುವ ಬಗ್ಗೆ ಹಲವಾರು ದೂರುಗಳು ಸ್ವೀಕೃತವಾಗಿರ್ತವೆ. ಹಾಗೂ ಭಾರಿ ಹಣಕಾಸಿಗೆ ಪೂಜಾ ವೃತ್ತಿಯನ್ನು ಪರಭಾರೆ ಮಾಡುವುದು ಮತ್ತು ಇಲಾಖೆಯಿಂದ ಅಧಿಕೃತವಾಗಿ ನೇಮಕವಾಗದ ವ್ಯಕ್ತಿ ದೇವಾಲಯದ ಪೂಜಾ ಕೈಂಕರ್ಯ ನಡೆಸುವುದು ನಿಯಮ ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂಡ್ ಯು ಶುಡ್ ನಾಟ್ ಗಿವ್ ಯಶವಂತ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ.
ಪ್ಲೀಸ್ ರೀಡ್ ಇಟ್.
ಆದ್ದರಿಂದ ಇನ್ನು ಮುಂದೆ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಅನುಸೂಚಿತ ದೇವಾಲಯಗಳ ಅರ್ಚಕರು ರಜೆ ಮೇಲೆ ತೆರಳುವ ನಿಗದಿತ ಅವಧಿಯವರೆಗೆ ಮಾತ್ರ ಬದಲಿ ವ್ಯವಸ್ಥೆ ಮಾಡತಕ್ಕದ್ದು ಹಾಗೂ ರಜೆ ಮತ್ತು ಬದಲಿ ವ್ಯವಸ್ಥೆಯ ಸಕಾರಣ ಹೊಂದಿದೆ ಎಂಬ ಬಗ್ಗೆ ಆಯಾ ದೇವಾಲಯದ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು, ಆಡಳಿತಾಧಿಕಾರಿಗಳು, ವ್ಯವಸ್ಥಾಪನಾ ಸಮಿತಿಯ ಅವರು ಆನುವಂಶಿಕ ಮುಕ್ತೇಸರು ಪರಿಶೀಲಿಸಿ ದೃಢಪಡಿಸಿಕೊಳ್ಳತಕ್ಕದ್ದು. ಅಲ್ಲದೆ ದೇವಾಲಯದ ಸದರಿ ಅರ್ಚಕರು ಅವರ ಸರದಿ ಪೂಜಾ ಕೈಂಕರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸ ಸಾಧ್ಯವಾಗದೇ ಇದ್ದಲ್ಲಿ ಅವರ ಪೂಜಾ ಸರದಿ ಹಕ್ಕನ್ನು ಕಾಯ್ದಿರಿಸಿ ದೇವಾಲಯದ ದೈನಂದಿನ ಪೂಜಾ ಕೈಂಕರ್ಯಗಳು ಸುಗಮವಾಗಿ ನಡೆಸುವ ಹಿತದೃಷ್ಟಿಯಿಂದ ಮುಂದಿನ ಸರದಿ ಅರ್ಚಕರು ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಅನುವು ಮಾಡಿಕೊಡತಕ್ಕದ್ದು. ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಸದರಿ ಅರ್ಚಕರನ್ನು ಬಿಟ್ಟು ಬೇರೆಯವರು ಅನಿರ್ದಿಷ್ಟಾವಧಿಗೆ ಬದಲಿ ವ್ಯವಸ್ಥೆ ಮಾಡೋದು.
issued on 25/1/2021.
Despite of this, the executive officer allowed him to continue this on the basis of this general power of attorney, third party perform puja. Complaint was given, petition was given to the commissioner. Annexure H, Millard, page 41, Millard.
Yes.
The petitioner has given a petition and has been referred. Page 42, Millard. Sorry, Millard. Page 42, Millard.
Yes.
ಕೊಲ್ಲೂರು ಶ್ರೀ ಮೂಕಾಂಬಿಕಾ ದೇವಾಲಯದ 4 ಜನ ಅರ್ಚಕರಿದ್ದು ಅವರುಗಳು ದಿ ಅನಂತ ಅಡಿಗ, ರಾಮಚಂದ್ರ ಅಡಿಗ.
ಓದ್ಬೇಕಾಗಿಲ್ಲ. What happened?
He has said that there's a GPA, through GPA, the permission that cannot be granted, and moreover this person has not approved by the commissioner.
ಸರಿ.
Yes,
ಆದ್ದರಿಂದ ಸೆಕ್ಷನ್ 9(1) ರೀತ್ಯ
ಹೌದು
ಅನಂತ ಅಡಿಗರ ಮರಣಾನಂತರ ಓದಿ ಕೆಳಗಡೆ ಲಾಸ್ಟ್ 4 ಲೈನ್ಸ್.
ಈ ರಾಮಚಂದ್ರ ಅಡಿಯವರ ಕಾನೂನು ಸಮ್ಮತ ನೇಮಕಾತಿ ಇಲ್ಲದೆ ಅರ್ಚಕರಾಗಿ ಮುಂದುವರೆಯಕ್ಕೆ ಅವಕಾಶವಿಲ್ಲ. ಆದ್ದರಿಂದ ಸೆಕ್ಷನ್ 9(1) ರೀತಿಯ ಅನಂತ ಅಡಿಗರ ಮರಣಾನಂತರ ತೆರವಾಗಿರುವ ಅವರು ನಿರ್ವಹಿಸುತ್ತ ಅರ್ಚಕ ಹುದ್ದೆಗೆ ಬೇರೆ ಅರ್ಚಕರ ನೇಮಕ ಮಾಡಲು ಸೂಕ್ತ ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಸೂಚಿಸುವುದೇ ಅಭಿಪ್ರಾಯ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇಲಾಖೆ ಕಾನೂನು ಸಲಹೆಗಾರ ಅಭಿಪ್ರಾಯ ವರದಿ ಅನ್ವಯ ಕೊಲ್ಲೂರು ಮೂಕಾಂಬಿಕಾ ದೇವಾಲಯದ ಅರ್ಚಕರಾಗಿದ್ದ ಅನಂತ ಅಡಿಗರ ಮರಣಾನಂತರ ತೆರವಾಗಿರುವ ಅರ್ಚಕ ಹುದ್ದೆ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೊಡಲಾಗಿದೆ. ಬಿಕಾಸ್ 9(1) ನಲ್ಲಿ ದಟ್ ರಿಪೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೆಂಟ್.
ಯಾರಿಗೆ ಕೋರಲಾಗಿದೆ?
ಅವರು Committee of Management has to pass a resolution, send it to the commissioner for approval as per section.
ಅವರೇನು ಕಮಿಷನರ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ ಅವರಿಗೆ
ವಾಟ್ ಕೈಂಡ್ ಆಫ್
ಅವರಿಗೆ board of committee of management, they have to make this one pass a resolution and send it for approval for the commissioner under section 9(1). That is the procedure. Therefore you take action in accordance section 9(1). Then again at this one he has filed that fifth respondent filed a review petition before the government.
Under which provision?
That's a review petition is that
what is it?
That the order is annexure L. This review petition
under which provision it is filed? (63)
Division power 63A, 63B minute review by the government. State government may call for and examine records of any proceedings or order passed by the commissioner or deputy commissioner for the purpose of satisfying itself as to correctness, legality or propriety of any order are proceeding and may, after giving reasonable opportunity to the interested persons, to be heard.
63B.
63B. Yes, taken a this one, where I have appeared and filed a detailed objections.
Yes.
Statement annexure K, page
Yes.
45.
Ah.
I have given all these ones because they are not Archakas, and the other than Archakas, they are all, they are not at all holding any post. On the basis of that.
ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ವಾದಿಯಾದ ಶ್ರೀ ಪ್ರಭಾಕರ್ ಅಡಿಗ ಸನ್ ಆಫ್ ಸುವರ್ಣ ಇವರ ಮನವಿ ಕುರಿತು ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ಮತ್ತು ಧರ್ಮದಾಯ ದತ್ತಿಗಳ ಅಧಿನಿಯಮ ಪರಿಶೀಲಿಸಿ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಆಯುಕ್ತರು.
Yes, the order is this manner. The section 9 ಕೆಳಗಡೆ ಕಮಿಷನರ್ ಮಾಡಬಹುದಿತ್ತು ಅಂತ. Commissioner has not considered this. Section 9 ಗೆ there must be an application by the persons to appoint him as Archaka. This fifth respondent has not given any petition for appoint him as Archaka. He has only this one. I have given a general power of attorney to the sixth respondent. You allow me to perform puja. Then he again set aside that order without giving reasons. When I have stated my statement of objections, detailed.
That order is not set aside.
No,
Where it is set aside
and remanded.
ಎಲ್ಲಿ where it is set aside?
ಮೇಲ್ಕಂಡ ಆದೇಶ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣ ವಾದಿಯಾದ ಪ್ರಭಾಕರ್ ಅಡಿಗ ಗೋಪಾಲ್ ಕೃಷ್ಣ ಸುವರ್ಣಸೋ ಧಾರ್ಮಿಕ ಮರುಪೊಲಿಸಿ ಮುಂದಿನ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವಂತೆ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯ್ತು.
That order is not set aside.
ಹಿಂತಿರಿಸಿದ ರಿಮೈಂಡ್ ಮಾಡಿದೆ.
That order is not set aside.
But yes.
Yes, madam.
No, yes, remanded to the commissioner, my lord.
Huh? ಯಾಕ್ರಿ?
Petition copy is served. Government copy served. Before filing, before filing.
ನೀವು respondent number 1 is principal secretary revenue department. That is not the way you to array the state government as a party. ನೀವು ಮಾಡಿರೋ ತಪ್ಪದು.
ಅವರು
ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಸೊ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ದಿ ಸೆಕ್ರೆಟರಿ ಅಂತ ಬರ್ದಿದ್ರೆ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅಂತ ಅವ್ರಿಗೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿರೋರು.
ಆರ್ಡರ್ ಪಾಸ್ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು.
ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ ಸರ್. ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಸ್ಟೇಟ್ ಯು ಶುಡ್ ಸೇ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. Yes, learned AGA takes notice for response number 1, 3, 1 and 3. Issue emergent notice to response number all the other respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that in spite of the commissioner directing by order dated 25/3/2022 at annexure H that the executive officer, the second respondent executive officer of Sri Mukambika Temple, Kollur, and the managing committee shall take necessary action in terms of the circular dated 25/1/2021 issued by the commissioner, Department of Religious and Charitable Endowments Department, the state government, in a revision petition filed at the hands of respondent number 6 has passed the impugned order dated 10/8/2023 at annexure L, remanding the matter back to the commissioner. Stop. Learned counsel submits that it is clear from the circular dated 25/1/2021 issued by the state government that the archiveship of a notified institution shall not be carried out on the basis of a power of attorney or any other such entrustment to a person other than the archak, who is entitled to function in terms of the provisions of the act, comma, no action is taken by the executive officer and the managing committee to comply with the circular issued by the state government. So on the other hand, the state government has itself violated the circular by passing the impugned order, directing the commissioner to take action in accordance with section 63 of the act. So, next para. Release this matter on 10th of October 2023. Stop. In the meanwhile, the learned AGA shall secure instructions at the hands of the state government as to why action is not being taken to implement the provisions of the circular dated 25/1/2021 in the matter of the third respondent, Sri Kolluru Mukambika Temple. So, yes.
The is a prominent educationist, my lord. He has a passport, my lord, to his credit, my lord, which would expire in 2026. Annexure B.
Huh?
The passport, my lord, would expire, my lord, only on 13/10/26. Now, my lord, since the book is over, my lord, he repeatedly visits other countries, my lord, for the purpose of educational activities, my lord, including lecture and all that. Since the book is complete, my lord, he makes an application which the authorities say that it will be considered as a renewal application. If they, when they renew the application, my lord, they have issued annexure E, page 59, wherein they refer to 3 cases, my lord, against the petitioner. That is, my lord, 42 of 2016. You will find page 59, para 1. That's actually 42 of 2019, 16 number 1. Number 2 is that, my lord, crime number 53 of 2019. And another case is that crime number 54 of 2019. So far as the first case is concerned, my lord, this honorable court has stayed at page 36, may kindly be seen, my lord. The report has been submitted, and against which, my lord, a protest petition was filed and re-investigation was ordered. And therefore it is stayed as per page number 36. Number 2 is that, my lord, 53 of 2019, which has been passed by this honorable court, my lord, the order copy of which, my lord, I have produced at page 58 itself. And 54, my lord, I am not concerned because my name is doesn't find a place there at all. One Mrs. Sudha Rao, my lord, is there. With all this, my lord, I brought to the notice of the authorities that I am repeatedly required to go, and I have been doing this from last 8 to 10 years now. Now they are insisting upon obtaining.
They have asked you to. They have asked you to clarify.
Yes, I have done it, my lord. Visit either the B report. You lordship kindly see last para of page 59. You are therefore advised to either get the B report accepted by the relevant court or get the travel permission from the relevant court as mentioned. In the matter of, my lord, renewal application, my lord, the question of obtaining any permission from the court, my lord, would not arise.
Sir, you are only required to clarify. Why didn't you do it?
I have already done it.
But our passport authorities, I have went there, you can't issue such an endorsement. Please reconsider that. No, they are insisting upon. They get the instruction.
Learned Central Government Standing Council, Shri Umesh PB has entered appearance for respondent number 1. Learned AGA takes notice for respondent number 2. Learned Counsel for petitioner is directed to serve a copy of the writ petition along with annexures on Learned Counsel, Learned AGA. Next para. Learned Counsel for the petitioner submits that since the passport book of the petitioner is completely used, the petitioner sought for issuance of
A fresh passport.
a fresh passport book. So, however, the first respondent is treating the application as a application for renewal of the passport. So, nevertheless, in terms of the impugned communication at Annexure E dated 8/9/2023, it is stated that there are 3 criminal cases pending against the petitioner. Full stop. Learned Counsel submits that the petitioner has clarified to the first respondent that no such criminal case is pending against the writ petitioner. And the third of them is not against the petitioner.
I have produced the affair.
Full stop. It is submitted that in spite of such clarification, the first respondent is not taking action to issue a fresh passport book. Full stop. Next para. Renewal alla anta neevu helta idiralla. It is not a renewal, sir.
I'm sorry. First, fresh passport.
Learned Central Government Standing Council seeks for a short accommodation to secure instructions and make submission. Full stop. Release this matter on 10th of October.
Wait, my lord.
Yen madak
But renew ಮಾಡಿದ I will be able to go, my lord.
ಹಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
On record.
ಹಂಗ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಸರ್. Yes.
Yes. On the proposal made by the respondent number 5, the respondent number 4 permitted to open rowdy sheet against the petitioner. On the basis of isolation, only one case registered against.
Learned AGA takes notice for all the respondents. Learned Counsel for petitioner is directed to serve a copy of the writ petition along with annexures in the Learned AGA. Please stop. Next para. Release this matter on 10th of October 2023. Full stop. Learned AGA is directed to secure instructions and make submission. Yes.
Passport, you know.
Huh?
2018. The criminal case was pending against me. From 2015, I produced a charge sheet or gist of charge. And it is still pending. Trial is going on. The matter is still pending since my mother. And the second son's marriage is fixed in Madinah of Saudi Arabia. Immediate period I want to go to 18th is the marriage, 18/10/2000.
What is the difficulty?
His passport is not there. I had applied since it was in clarification only that my case is pending. Till today the case is not over. Only 5 witnesses have been examined. The offense is under 457.
Then you will have to take permission from that court.
But there is no bail condition that you have to take permission.
The requirement of the passport authority is that if there is a criminal case pending, you will have to get a no objection or permission from the competent court where the case is pending. It is as simple as that.
With that observation.
Purple. Learned Central Government Standing Council, Sri Aditya Singh. Is interested with the matter on behalf of all the respondents. So, next para. The grievance of the petitioner is that he is required to travel to Saudi Arabia to attend his son's marriage, which is scheduled to be held on
18/10/2023.
18th of October 2023. So, however, his application for issuance of passport is kept pending on the ground that a criminal case is pending against the petitioner in
CC number.
CC number 1206 of 2014 on the file of the principal civil judge and JMFC, Nelamangala. Stop. Next para. Learned Central Government Standing Council submits that in terms of the requirement of law, and the regulations and the guidelines issued by
statutory notification dated, I can give the number here. Pass on.
in terms of the statutory notification dated so and so. Wherever, whenever it is found that the applicant for passport is having a criminal case pending against him or her, such an applicant is required to secure permission from the concerned court where the case is pending, permitting the regional passport authority to issue the passport. Full stop. Next para. Learned Counsel for the petitioner submits that the petition may be disposed of, permitting the petitioner to file necessary application before the principal civil judge and JMFC, Nelamangala in CC number 1206 of 2014 to grant permission to the petitioner to travel abroad and a direction to the regional passport authority to consider the application filed by the petitioner for issuance of passport. Full stop. Next para. The submission of the Learned Counsel for petitioner is placed on record. Full stop. Accordingly, the petition stands disposed of while granting liberty to the petitioner to file necessary application before so and so in CC number so and so to seek permission to leave the country, while also directing the regional passport authority to consider the application of the petitioner for issuance of the passport. Ordered accordingly.
Operative portion of the idea is.
ನಾಳೆನೇ ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ. Yes.
Dispose of the matter at least.
But I have stated that I have mentioned the date also. Yes.
Yes. Against the e-auction notice issued on 1/9/2023, and they want to auction it on 10th. It is just for 82 lakhs is the price they have quoted. 82 just for 82 lakhs. And actually, at the time of sanctioning the loan, it was 2 crores. At present, it is 5 crores is the value of the property. Number two, my building was encroached. That is due to building road construction. It was demolished, so I had to pay a lot. And this honorable court itself has given us an order for payment of compensation, which is not yet received. So we humbly request this honorable court to give us time. Some stay. We will remit whatever amount is placed. 20-25% amount deposit immediately, so that the present e-auction notice may be rightly stayed.
What is the outstanding loan amount?
It's around 52 lakhs.
No.
In the notice only they have given.
There are two accounts.
Yeah, two accounts clubbed together. It's 52 lakhs.
54 lakhs, 13,000.
Yeah,
Not
54 lakhs, 13,000. 54.13. Yeah.
Don't say yeah.
Yes.
25% of the amount you'll have to deposit.
Yes, definitely, definitely, my lord.
Perfect. Issue emergent notice to the respondent. Learned counsel for the petitioners submits that the petitioners mortgage property which is worth more than 5 crores is ought to be put for auction. To recover a sum of rupees 54 lakhs 13,402, even in terms of the impugned auction notice dated 1/9/2023 at Annexure B. Learned counsel submits that the petitioners are ready and willing to deposit a portion of the outstanding amount within 4 weeks, and they would also undertake to clear the entire outstanding loan amount if reasonable time is granted, or they will ensure that the account is regularized on payment of the outstanding loan amount. Stop. Next para. Consequently, the respondent bank is directed not to proceed any further consequent to the impugned auction notice dated 1/9/2023 at Annexure D. Subject to the petitioners depositing 25% of rupees 54 lakhs 13,402 with the respondent bank within a period of 4 weeks from today, failing which the benefit flowing out of this order shall not inure to the petitioners, and the petitioners will be at the risk of having the writ petition dismissed. Full stop. Next para. Release this matter on 31st of October. ಹತ್ತನೇ ತಾರೀಕಲ್ವೇನ್ರಿ ಇರೋದು ಆಕ್ಷನ್? You will get it tomorrow. There is no difficulty. Yes. Huh?
Page number 8. Come to the fourth paragraph. If that we now intend to take possession of the property in terms of the order sought by the APM court, Bangalore in case number APM court.
Yes.
Order 3/10 of 2019. Dated 2019, the assistant of the jurisdictional authority is required. We have come interested in the work of enforcing the dignity act of the act to method applying interested credit number 3 business intake.
Yes. Yes.
The lordship, this is the miscellaneous petition order.
Why you have not produced it along with the writ petition?
I just got it. Belongs to different batch, different person. Property of, therefore, that's not for state of the state of the.
Why don't you give them a reply?
They did reason to us.
Where is your return reply?
I tried to personally met them. They
Oh.
didn't reply.
You are a defaulter.
True, I have produced the other document for that.
There must be some mistake, that's all.
I have taken loan.
You don't deny the fact that you are a defaulter.
I have produced it along with the document. Kindly turn to Annexure P.
So therefore, why didn't you give a written reply?
But I went and met them, they didn't reply to me.
No, sir.
That
cannot be a ground.
Because it belongs to different person, different bank, different scheduled property.
But you are not denying the fact that you are a defaulter.
After the settlement, I paid 3 lakh. My son's education loan has been cleared. Can you
Ah.
take Annexure B?
Hmm.
Wherein the bank itself has given no objection.
Huh? We are not concerned with that one. Whatever action they are trying to take now, if you are not denying,
Based on wrong.
not that, sir. Are you not, have you not availed the loan from the respondent bank?
I'm not denying.
Then?
I have paid what is the substantial loan even they.
Therefore, why didn't you give a written reply then? If you are not a defaulter, if there was no cause for them to take action against you, why have you not given a written reply? No, sir.
Conditional statement.
Issue emergent notice to the respondent. Yes. No, no. That is not the type of submission you are trying to make. Yes. Huh? Why? Huh. You can't make this kind of a submission, madam. You can't say, please issue notice. That is not the way. Huh?
Page 52.
Huh?
Record as requested.
Huh?
We have convicted.
Councillors made a request.
Page 52.
Huh?
Advocate Sirojin Ahmad would only like to state that the above named petitioner's mother is suffering from serious illness.
The request should either come from the person in custody or their parents or relatives or whoever. What do you want to do? Huh? Learned AGA, HCGP takes notice for both the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. We'll stop. Next para. Learned HCGP points out from annexure J that it is a communication made by the learned counsel on record to the chief superintendent, civil prisons, Belgavi, to release the person in custody on parole. So, HCGP submits that if no application is made in accordance with law, there is no question of granting parole to the person in custody. So, next para. Learned counsel for the petitioner seeks for a short accommodation. Full stop. Release this matter on 10th of October. Please take instructions and make submissions. Also,
Petitioner, the petitioner and his father have borrowed the loan from this respondent. Sum of it is 12,15,880,000.
Huh?
His father is the borrower, principal borrower is passed away during the COVID method. That manner they could not pay installment, they could not pay regularly. The respondent has issued an annexure possession notice. It is dated on 21/8/2023. By virtue of that, the take portion of the house property. Yes, is a tenant information. I am ready to take some conditional. Ready to update the due also. The court grants some time for updating the due amount. The due amount is to, as per the notice, 13,59,005 rupees.
Issue emergent notice to the respondent. Next para. Learned counsel for the petitioner submits that the petitioner's father, late Sri Rangayya, had borrowed money from the respondent NBFC. So the respondents have issued the impugned possession notice at Annexure A dated 21/8/2023. Threatening to take possession of the secured assets, that is the residential premises where the petitioner is residing along with his family members, for recovery of a sum of rupees 13,59,000. So learned counsel submits that if reasonable time is granted, the petitioner will pay the outstanding amount and get the loan account regularized. So in order to show the bona fides of the petitioner is also willing to deposit a portion of the demanded amount. So consequently, the respondent NBFC is hereby directed not to proceed any further consequent to the impugned possession notice dated 21/8/2023 at Annexure A, subject to the petitioner depositing 25% of rupees 13,59,000 with the respondent NBFC, within a period of 4 weeks from today, failing with so and so same. Release this matter on 31st of October.
Number 40, Mohammed Pasha C.
Yes.
In the year 2016, the petitioner and respondent got married.
Huh?
In the year 2016, petitioner and respondent got married. Petitioner who is working as a lecturer and the respondent also well qualified MSc PhD. We also pursuing job in the private university.
You are agreed of Annexure D.
Yes.
Direction for interim maintenance
25,000
and educational expenses of rupees 25,000 per month to petitioners number 1 and 2.
The respondent who misled the trial court about that, saying that the petitioner trying a salary of rupees 4 lakh rupees. It is not correct. The impugned order reports on 18/3/2023. IN number 3 with respect to 25,000. IN number 3.
Yes.
Lordship, when the IN number 3 was filed, the petitioner was not able. His father was suffering from chronic ailment. Ultimately, he was passed away. Simultaneously, his mother also suffering from chronic ailment. Even today, she is bedridden. For the sole reason he has not contacted his counsel, not had an objection. That opportunity was misused. He misled their trial court, saying that he is lying for like this happened. This regard, I have produced the relieving letter in page number.
Relieving letter.
Page number 61. And it's Annexure J. In the year 2013 to 2020, the petitioner who was worked in Abu Dhabi, Gulf country, as a program manager and business lecturer. That point of time, till his relieving, he was earning only 80,000 rupees. 80,000 rupees. 80,000. Thereafter, he came back to India and got a job in
Southeast Asian Education Trust.
Yeah. In the year 2022, he got appointment order wherein even today he is working as lecturer.
Assistant professor. Assistant professor.
Yes, Lord. Just 25,000 rupees. That is the truth, Lord. Now he has to take care of his mother and his sister as well as him also. For drawing 25,000 rupees, if he paid the entire salary amount to the respondent, so what about the fate of his mother and petitioner. That for the sole reason I filed this. You know, so many things in this matter. When the petitioner who was in the Gulf country responded with a due respect motion, and not as a assessing the character of the respondent. The real facts were based.
No, all that is not necessary.
Yes.
You have filed the
Main petition, I filed the objection.
copy of the statement of account at page number 69.
Yes.
Huh?
Yes.
What is the salary that you are receiving?
In that point of up to 80,000, still he is relieving from the job.
2022, sir.
Yes.
You were appointed when? 17/5/2022.
Yes, Lord. 23,600. 8/9/2022. Yes, 17.
23,600.
House.
ಆಮೇಲೆ
ಆಮೇಲೆ
19,433. How?
Earlier 19,433.
Not earlier. It is going reverse order.
ಹೌದು, ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ. ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ ಸರ್.
And it looks like you are not even drawing any salary now. Then
I got the instruction, the petitioner, he is drawing his salary up to 24,000 as of today.
but your statement of account does not reflect so.
Till March, the statement of the thereafter not corrected. He is out of station.
ಅಲ್ಲ ಅಲ್ಲಿವರೆಗೂ ಏನು ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ವೇ? After October 2022.
ಕ್ಯಾಶ್ ತಗೊಂಡು ಏನು ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಇವೆಲ್ಲ ಮಾಡ್ತಾರೆ ನಮ್ಮವರು. All this will be done at the request of the person. We can't take it on the face value.
Yeah, even 25 ಗಿಂತ ಜಾಸ್ತಿ ತಗೊಂತಾರೆ. ಕೂಡ private account ಆಗಿತ್ತು, ಕ್ಯಾಶ್ ತಗೊಂತಾರೆ.
That has been taken into consideration. The qualification of the respondent is shown as MBA PhD and his income is shown as 4 lakhs per month.
Misled with the respondent. Misled with the respondent.
What were you doing?
That point of time,
Why don't go and file the same information before the court?
no, we will file. That point of time, when the order was for the objection was not filed. We have taken the advantage for not filing the objection. Even the
No. You have submitted that you are drawing only a salary of rupees 23,000.
yes, main
But you didn't file this information.
supportive documents have not been placed. Even objection also not filed. Main petition you objection ಹಾಕಿದೆ ಅಷ್ಟೇ. I3 ಹಾಕಿರ್ಲಿಲ್ಲ. Assets and liability also not filed yet. Even the respondent who is a well qualified MSc PhD, ಅವರು professor in university.
Purple. Issue emergent notice to the respondents. Next para. Learned counsel for the petitioner submits that although a submission was made by the petitioner before the learned principal judge of the family court that he is drawing a salary of rupees 23,000 only. The same was not accepted, and the learned principal judge of the family court has now directed the petitioner to pay monthly interim maintenance and educational expenses of rupees 25,000 per month to the respondents. Stop. Learned Counsel submits that the petitioner was earlier working in Saudi Arabia, Abu Dhabi, and after he quit the job and came back to India, he is appointed as assistant professor at Southeast Asian Educational Trust. And in terms of the appointment order at Annexure K, dated 17/5/2020, his consolidated monthly salary is rupees 25,000. Stop. Learned Counsel has also drawn the attention of this court to the statement of accounts, where initially a sum of rupees 23,600 towards salary was deposited into the account of the petitioner. Stop. Learned Counsel further submits that the petitioner also has a ailing mother who he needs to take care of. Stop. Next para. Consequently, as an interim measure, the petitioner is directed to pay monthly interim maintenance and educational expenses of rupees 15,000 per month to the respondents. During the course of these proceedings and until further orders. Please stop. Yes.
Yes. Petitioner.
Yes.
Petitioner is an educational institution.
Huh?
Petitioner is an educational institution. Garnish order issued under section 45 of the ESI Act is challenged before this court.
Yes.
In case there is under 38. Lords, by the virtue of this garnish order, the accounts of the petitioner stands frozen. In the light of section 107 of the Karnataka Education Act.
What is this description of the petitioner?
It's a society which is incorporating and which is established an educational institution. The permission that has been granted is at page 31.
Islamic Baitul Mal.
Baitul Mal. It's a society.
It's the name of the society.
It's the name of the society. And it has established a school under the name and still IBM school.
Yes.
The certificate of registration at page 31, Annexure A.
Yes.
It was established way back in the year 1957. Now, there is a kind of a debate which has been going on whether the education institutions are liable to contribute towards the ASI contributions or not. And for the failure, a garnish order in the section 45C of the ASI Corporation Act has been issued as against the petitioner, wherein the accounts of the petitioner stands frozen. That is at page 37 to 38.
Yes.
So, in terms of section 107 of the Karnataka Education Act,
yes. Yes.
Restriction or alienation 107. Restriction or alienation of property or private educational institution. Notwithstanding anything in law for the time being enforced, no say, mortgage, lease, pledge, charge, or transfer of possession in respect of any property or private education shall be made or created except with the previous permission in writing of the competent authority on an application made in this behalf. A kind of a garnish order, nothing less than comes under the ambit of charge of property. And in the similar circumstances, this honorable court can grant an interest rate.
Learned AG takes notice for respond number 4. Issue emergent notice to response number 1 to 3. The petitioner is also permitted to serve a copy of the writ petition along with annexures on learned counsel Srimati Geeta Devi Papanna, who is said to be on the panel of the respondent ESI Corporation. Stop. Next para.
Sorry, 1 to 2.
Next para. Learned counsel for the petitioner submits that the law is still not settled in the matter as to whether an educational institution would come under the purview of the employee state insurance
Operation.
No, what is that act? Under the provisions of the Employees State Insurance Act, 1948. So, nevertheless, it is submitted that the impugned garnishee order under section 45G of the ESI Act, 1948 at annexure L dated 14/8/2023.
C. C.
Huh?
C.
C, annexure C, would be contrary to section 107 of the Karnataka Education Act, 1983. So, it is submitted that the said provision mandates that no charge shall be created on the property of a private educational institution unless previous permission in writing is taken from the competent authority on an application made in that behalf. Stop. Learned counsel submits that consequent to the impugned order at annexure C, the bank account of the petitioner trust society with the third respondent, State Bank of India, Bangarpet branch, is also freezed. Stop. Learned counsel would further submit that under similar circumstances, this court in WP number 154 of 2022, by order dated 27/1/2022. Directed the respondents not to take coercive action against the petitioner. Stop. Consequently, there shall be an ad interim order of stay of the impugned order dated 14/8/2023 at Annexure C, till the next date of hearing. Correct.
Number 3, India. Number 12, Arunji. Number 16. One.
Lordship heard this matter in part. The tenants have filed this writ petition challenging the attachment made by KPI. Now, once IPC is admitted and resolution professional is appointed, he has to take over the assets of the company, and the lease period has expired. In this case, tenants have no manner of right, title, or interest. The company responding number 7 has filed a separate writ petition and it has obtained stay of the KPID proceeding. Now, by virtue of this interim order, the petitioners are not vacating and handing over the possession of the property to the resolution professional. Relevant 22 except that lease period has expired.
I appear for the petitioner, Milad.
Yes.
My colleague is filing some citation, Milad.
Yes.
The respondent 7 can take due process of law, Milad. They can approach civil court to file eviction suit, Milad.
Sir, who are you? You are a tenant. How can you make this kind of submission?
Let them follow the due process of law, Milad. Kindly peruse.
Who are you to say that? That is the objection that is being raised.
Yeah, kindly peruse.
You are only a tenant there. How can you raise this kind of an objection? And how are you permitted to maintain this writ petition is the objection that is being raised.
I just submitted my citation, Milad. Kindly see the page number 6, Milad. In my
yes.
Page number 6.
Of which judgment?
No, that is the
embassy.
The
embassy property.
Mumbai, that asset reconstruction company versus President Fastness Milad held the jurisdiction to grant relief to recovery.
Please, sir, what has been given to me is embassy property developments.
Yes, Milad, that is in my written submission, Milad. Kindly for page number 6, written submission. Page number 6, paragraph 13, Milad. Para 13. Identical situation, National Law Commission Tribunal, Mumbai, has held as in the judgment and the asset reconstruction company versus President Fastness held that jurisdiction to grant relief to recover the rent from a tenant and the eviction of the tenant from the property of the corporate debtors lies exclusive domain of the civil court. In the case of hand, though the eviction of tenant is not fall within the purview of the NCLT, falls within the ambit of Transfer of Property Acts and the domain is in the civil court, my lord. In the next judgment, the para 14, my lord.
Why have you not produced that judgment? Why are you reading like this by giving? Where is the copy of that judgment?
Now I will produce the judgment, my lord, in the next date, my lord. I full set of with the 62 pages judgment.
No.
I will produce it on next date, my lord.
No, sir.
Next date.
No.
Read them in their own statement, my lord. Kindly peruse their application.
On the previous date of hearing, this court had recorded the submission of the learned counsel for respondent number 7. That respondent number 7 company that in respect of respondent number 7 company, a resolution professional has been appointed by the National Company Law Tribunal. And this writ petition could not have been maintained at the hands of the petitioners who claim to be tenants under the 7th respondent company. So, however, at the request of the learned counsel for the petitioner, who had stated that he is out of station and had sought for a short accommodation, this matter was directed to be listed today. So, learned counsel for the petitioner seeks to submit that there are judgments of the Honorable Supreme Court to the effect that the interest of the tenants are to be protected, while action is sought to be initiated against a company. Nevertheless, the judgments are not, copies of the judgments are not produced by the learned counsel. Full stop. Next, consequently, the respondents are permitted to proceed in accordance with law. Full stop. Release this matter on 10th of October 2023. Yes. Learned counsel for petitioner has filed a memo dated 3/10/2023 stating that the matter has been settled amicably between the parties and therefore the petitioner does not press the writ petition. We'll stop. Next para. The memo is taken on record subject to all justice submission. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
Same connected.
Same, huh? Same.
Last case of hearing, directed responding way for hand over the custody of the child, but the child was not handed over. You have specifically remarked that she would be liable for contempt. Despite the order, she is not handed over.
Same day evening, my lord, we have called out the petitioner. The petitioner is no answer to the phone, my lord. After the deed was separated from paper, I the apologies, my lord.
What do you want to do now?
But we are ready to hand over the child.
I have not instructed my client to come today, my lord, before this court, because the order was to hand over the child there at Mysore.
We called twice, but he is not received the call and not received.
There be a direction to hand over the child at.
ಅಲ್ರಿ ಫೋನ್ ಕಾಲ್ ಮಾಡೋದಲ್ಲ, ಹೋಗ್ಬಿಟ್ಟು ನೀವು ಹ್ಯಾಂಡ್ ಓವರ್ ತಾನೆ ಮಾಡ್ಬೇಕು.
It's difficult. Difficulty, my lord, the petitioner is not the resident of Mysore, he is in Hoskote. The kid is the grandmother of the respondent. Whenever the child is get back the respondent mother, they are threatening every time. There are several complaints is lodged before this court. Last case also filed the NCR.
Why would that threaten when you are handing over the child, sir?
My lord, every time also, whenever.
Here is the question of threatening when you are handing over the child.
Lord,
ನೀವು ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅವ್ರು ಗಲಾಟೆ ಮಾಡ್ತಾರ, ಅದು ಬೇರೆ ವಿಚಾರ. We are not going to hear all this now. We will give an opportunity to have your say while hearing. ಈ ಟೈಮಲ್ಲಿ ಈ ತರ ಎಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಕಾಂಟ್ರರಿ ಟು ದಿ ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್. ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the petitioner submits that in spite of specific orders being passed by this court on 29/9/2023 that the child shall be handed over to the petitioner's father between 8 p.m. to 9 p.m. on 1/10/2023, the child was not handed over to the petitioner. Full stop. Next para. Kodi. Per contra, learned counsel for the respondent has filed an affidavit of the respondent affidavit dated 4/10/2023 of the respondent stating that the respondent made effort calling the petitioner at about 8 p.m. on 1/10/2023, but the petitioner did not answer the call. Stop. It is stated that the child was also suffering from fever the next day, and therefore the respondent could not hand over the child to the petitioner. Stop. The respondent has tendered unconditional apology for not being able to comply with the directions passed by this court. Stop. Next para. The learned counsel would submit that the respondent is present before this court along with the child, and she is ready to hand over the child to the petitioner. Stop. However, learned counsel for petitioner submits that the petitioner is not present before this court, and the learned counsel will not be in a position to take the custody of the child. Full stop. Therefore, it is submitted that the child may be directed to be handed over to the petitioner in Mysore this evening.
I will instruct them to be present.
This evening.
This evening. I'll be.
Stop. Next para. Consequently, the respondent is hereby directed to hand over the child to the petitioner at 8 p.m. today.
Respondent's mother's house.
Any neutral place. Any neutral.
Respondent's mother's house.
ಅವರು ಅಲ್ಲಿ ಮಗು for the sake of education.
Respondent ಅಲ್ಲಿ petitioner also Mysore ಇಲ್ಲ. Is the resident of Hoskote village. Whenever the ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ, ಇಬ್ಬರು ಮಕ್ಕಳನ್ನು ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಇದ್ದಾರೆ, ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲಿ ಎಜುಕೇಶನ್ ಮಾಡ್ತಾರೆ ಮೊದಲನೇ ಮಕ್ಕಳ.
ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮದರ್ ಅಂತದೆ.
ತಾಯಿ ಮಕ್ಕಳ ಜಗಳಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಸಾಕಾಗಿದೆ. ಯಾವಾಗಲೂ ಪ್ರಾಬ್ಲಮ್ ಅಮ್ಮನೇ ಮಗುನ ಕಿಡ್ನಾಪ್.
ಯಾರ ತಾಯಿದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ವೈಫ್.
ಅವ್ರದೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಇದು ಏನಾಯ್ತು ಸ್ವಾಮಿ, ಇನ್ಸಿಡೆಂಟ್ಲಿ ಫಂಕ್ಷನ್ ಅಲ್ಲಿ ಹೋದಾಗ ಫಂಕ್ಷನ್ ಅಲ್ಲಿ ಮಗುನ ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ದೆ ಅದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಆಯ್ತು.
ಇಲ್ಲ ರೀ, ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಹೌ ಹರ್ ಮದರ್ ಇಸ್ ಅ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ಹರ್. ಏನು ಎಲ್ರಿ, ವೇರ್ ಡು ಯು ವಾಂಟ್ ಟು ಟೇಕ್ ದಿ ಕಸ್ಟಡಿ ಆಫ್ ದಿ? ಎಲ್ಲಿ?
Her mother's place, but it's because ಏನಾಗಿದೆ, ಈ petitioner is working at a KMF in Mysore at Siddhartha Nagar. Sake of education is I mean, yes, both the children are studying in Mysore, and that's why both the children are at the respondent's mother's house. Respondent's mother's house for sake of education. He belongs to us village. Hoskote village of
Hoskote. Mysore ತಾಲೂಕು.
Therefore, for the sake of education, he is realizing the ಅಲ್ಲಿ ಬಿಟ್ಟು ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
What kind of order this is then? You are not there to take care of the children.
I come daily.
ಏನ್ ಡೈಲಿ?
Statement by the is wrong.
ಅಲ್ಲ ನೀವೇ ಒಪ್ಕೊಂತ ಇದೀರಲ್ರಿ. ನಾವು ಯು ಆರ್ ಸೇಯಿಂಗ್ ಲೆಟ್ ಹರ್ ಲೀವ್ ದಿ ಚೈಲ್ಡ್ ಇನ್ ಅವರ್ ಮದರ್ಸ್ ಪ್ಲೇಸ್ ಅಂತ.
ಅಲ್ಲ ಅಂದ್ರೆ in the sense how he'll come and take the custody ಅಂತ ಹೇಳಿದ್ರು. Come and take the custody of.
He is going for work in the morning and returning only late in the evening.
His grandparents are there at home. She is living with her paramour in the case. On that ground, this honorable court states the order of the family court. He is living with her paramour. I have made a categorical statement, and the petitioner has filed an affidavit before this court. Some request.
In. ಅಲ್ಲ ನಿಮ್ದು ಮನೆ ಇಲ್ವಾ?
ಅಲ್ಲ ನಾನು ಇವರು ನಮ್ಮ ಜೊತೆ ಒಂದೇ ಮನೆಯಿಂದ ಏನಾಗಿದೆ, he was living with his father-in-law and mother-in-law, and both the children were being raised here in Mysore city for the sake of education. She developed intimacy.
So you are residing with your in-laws?
Yes, in-laws. Now their father and mother are against her because.
So, I will not say to hand over the child to the respondent's mother.
Petition.
You have to take the custody at 8 p.m. You should be present there. ಏನ್ ಹೇಳ್ದೆ?
The respondent is hereby hand over the child to the petitioner at 8 p.m.
8 p.m. this evening in Mysore.
ಯಾವ ಜಾಗ ಹೇಳ್ತಾರೆ ಅದರಲ್ಲೇ ಬಂದಂತ.
Huh?
She is saying that she is unable to come to her mother's place. ಅವರೇ ಜಾಗ ಸಜೆಸ್ಟ್ ಮಾಡ್ಲಿ, I will instruct him to go there and take the custody of the child. Because my learned friend submitted that ಅಲ್ಲಿ ತೊಂದರೆ ಇದೆ ಅವರಿಗೆ ಅಂತ. If they suggest a neutral place in Mysore.
No. He will be present. You let them let her hand over the child to him only.
Or this matter could be had tomorrow. I'll instruct him to be present and take the custody.
No, not necessary. Where is she residing? T. Narsipura. In the place where the petitioner is residing. Yes. Huh?
Again, I have no objection.
All the other directions given in the matter of visitation rights of the respondent shall continue till the next date of hearing. Yes. What are you don't know? Let us see. Yes.
Is the case which the FIR is filed, but he is not a part.
ಅದೆಲ್ಲ ಇವಾಗ ಬೇಡಮ್ಮ. Yes.
The case in which the FIR filed by one person.
On complaints of office objections,
Is filed.
matters come up for petitioner. Petitioner is not a party before the trial court.
The trial court before the FIR also.
Ah.
They are giving trouble unnecessarily calling upon me to produce the original document when there is a civil suit is pending between the parties. At page number 55, can permit to say. Civil suit is pending. The same person who has
Between
given.
whom?
Between the same parties.
Huh?
Between the same parties.
ಮತ್ತೆ you are not a party ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
So, ಇದು FIR ಅಲ್ಲಿ we are not a party.
Criminal complaint.
Criminal complaint not a party ಅಲ್ಲ.
Huh?
Not a party. in
Dr.
criminal
S. Anand versus
complaint, I am not a
Giridhar
party.
Prakash.
Matter is pending before the civil court regarding the matter filed by the complainant has filed a suit. Case number 5384 of 2021 before the City Civil Court, Bangalore, at page number 55, my lord. Each and every time the police has called me to produce the original documents before to the police station. To adjudicate it. When the civil suit is pending, the police has no jurisdiction to adjudicate any matter, my lord. That's all my submission. In this regard, there is also decision of dishonorable court regarding their lots of.
Where is the notice issued to you? Where is the notice issued to you?
29/9, they have issued the notice.
Huh?
They have issued notice. You present and produce the documents. Not related to civil suit, civil in nature. 29/9/2023, they have issued notice. In this regard, dishonorable court has held when the matter is civil suit is pending, the police has no jurisdiction, let them appear before the civil court and adjudicate the matter before them, between them. Page number 71, lordship has held, my lord. Page number 71 of the dishonorable court. The appraisal course of the order at 74, my lord. Also, the IGP has also issued a circular. When the matter is in civil nature, they have to approach the civil court. The police has no jurisdiction at all. At page number 75, the circular issued by the IGP, Director General of Police.
Office objection is overruled. Next para, learned AGA takes notice for all the respondents. The learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. Learned counsel for the petitioner submits that The sixth respondent, police, have been harassing the petitioner, calling upon him to produce the original general power of attorney dated 28/9.
16 or
16/10/2020.
21.
21.
Instructions are that the body of signatures on that. Purchased it from.
It's a civil matter, madam. They are already before the civil court.
Purpose of FSL report, my God.
That the civil court itself will do that. You don't have to worry about that. Another data?
For 28/9/2021.
21. Another?
Counsel for the petitioner submit that sixth respondent police have been harassing the petitioner, calling upon him to produce the original GPA dated 16/10/21.
In spite of the fact that the concerned parties are already before the civil court. In OS number 5384 of 2021. Stop. Learned counsel would further submit that a circular dated 22/5/2013 has been issued by the Director General and Inspector General of Police, State of Karnataka, directing the police officers in the state, having regard to a judgment of this court in the case of Sri T. Narayan Swamy versus the state of Karnataka and others in WP number 16524 of 2014, dated 6/1/2015, that if the dispute is of a civil nature, the police should not interfere in such matters and should not call the parties to the police station to produce any document relating to the civil dispute. Full stop. Next para. Learned AGA would submit on instructions that the respondent police have issued notice to the petitioner in terms of section 91 of the Code of Criminal Procedure, calling upon the petitioner to furnish, to tender the original of the power of attorney dated so and so. Since there is an allegation that the signature contained therein is a forged signature, and the same is required to be sent for experts' examination and opinion. Stop. Next para. In the considered opinion of this court, the civil court would have ample power to send a document for verification and experts' opinion. Full stop. Therefore, since the rival claimants are already before the civil court in OS number so and so, there is no need for the respondent police to call upon the petitioner to tender the original of the power of attorney. Stop. Or any other document for that matter. Full stop. Next para. Consequently, the writ petition is disposed of while specifically directing the respondent police not to call upon the petitioner or issue any notice calling upon the petitioner to appear in person in the police station or to tender any document. Stop. An endorsement in that regard may be issued to the complainant that since the matter is of a civil nature and the parties are already before the civil court, necessary application may be made before the civil court itself to secure the original of the power of attorney or any other document which is said to be in the custody of the petitioner. Full stop. Next para. Ordered accordingly. Yes. Then counsel for petitioner has filed a memo dated 29/8/2023 stating that the petitioner does not intend to prosecute the writ petition any further, and the petitioner has requested that the writ petition may be dismissed as withdrawn. We'll stop. Next para. The memo is taken on record subject to all just exceptions. Stop. Accordingly, the petition stands dismissed as withdrawn. Non-compliance of office objections.
Need a submission in respect to the nature of the petitioner industry. It's a proprietary concern, my lord. Unregistered. Whether nature of the petitioner's company. Submission is a proprietary concern. You got to get right license to run the rice industry. Not registered on the Companies Act. So submission we have made.
Lecture K.
Yes. Respondents ordered for transportation charges. Transportation charges to be made to the petitioners, but not ordered for interest on the delayed payment of transportation charges. Will be agreed by that, my lord, we are before this. Operative portion we are technically 124. It says transportation charges to be made in respect of the petitioners, but there is no finding or order of payment of interest on the delayed payment of transportation of charges.
So all of you are before the government.
Please,
in that appeal.
please, the representation with order of this court, are directed us to file a detailed representation before the chief secretary.
Yes.
Detailed representation.
Office objections are overruled. Yes. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Release this matter on 10th of October 2023. Learned AGA is directed to secure instructions regarding the prayer made by the petitioners. Petitioner Rice Mills.
Yes.
In the matter of payment of interest
Transportation charges you received.
on the transportation charges for delayed payment. Yes. Respondent. ఇక్కడ బన్ನಿ.
license in favor of the respondent. And I filed a vacating application after hearing the both the parties, directed the respondent to issue the license in favor of the respondent. So the website order then put in an order. Now.
Huh?
The order with the respondent. They were respondent for issuing the license for
ಮುಂಚೆ ನಾನು ನೋಟಿಸ್ ಮಾಡಿದ್ವಲ್ಲ that an order has already been granted in your favor. Past in, we have already noticed that one. How can you say it has become infructuous? That submission was already made and I've taken note of that. But in spite of that order, you are not permitted to operate because there is an interim order of stay here. Yes. So on the last occasion itself, I have directed that you may proceed to, you may be permitted to operate the PDS shop. Yes. Now the competent authority will have to consider the objection raised by the petitioner that you have furnished fake lease deeds. Okay, why have you given the permission to the society then? Petitioner Allah, now the order has been passed in favor of the fourth respondent society. The allegation of the petitioner that they have produced fake lease deeds. Therefore, their application could not have been considered. Who is going to consider that objections now? You have to consider. You will have to once again find out whether they have furnished any wrong information. If it is a wrong information, then the application is liable to be rejected then. We do not know, sir. That is why we are saying it is for them to find out the veracity of the documents.
Document last time, police document last time, directed to the publish the particular documents. Even today, they are not working. Day before yesterday, I am asking usually copy to verify whether it is bogus or not. Yes, I am asking. What are the portray full of details on verify model?
Matter is called out. There is no representation for the petitioner. Stop. Release this matter on 10th of October. 11th. All right. Matter is called out. There is no representation for the petitioner. Stop. The petitioner has not paid the process fee for service of notice on the respondent. Stop. No information is available whether the petitioner has complied with the directions issued by this court on 4/9/2023. Stop. Consequently, the relief given to the petitioner by order dated 4/9/2023 shall not continue. Stop. Release this matter on 10th of October 2023. Stop. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed.
This objection is not said. Corporation certificate is not serving.
Yes.
Page 20 minutes, I have produced the bylaws of the association itself. It's a registered society. It's page 20, election here, I have produced the bylaws.
Office objection is overruled.
This is Manoj, the society has formed a layout. What happened is, Manoj, sir, there is a provisional approval that has been granted, page 79. Manoj is the, I am the owner. Manoj, society has purchased the land. It is converted for non-agricultural residential use. Page 79, Manoj, respondent has issued the provisional layout approval. So what happened was, Manoj, the person by name Manoj MK Bay had filed an injunction suit against my vendor. So that suit, Manoj, was an ex parte decree was passed. Because my vendor challenges that decree. And Manoj, the first appellate court judgment is at Manoj page 104. In RA, that judgment was set aside. So as against
Not for
only with regard to the condition.
approval of the layout.
Yes, approval of the layout.
Local bodies matter then. How is it classified as GM?
It's classified as.
It is for you to classify, sir. The matter pertains to local bodies roster. Stop. Office is directed to list the matter, reclassify this matter as local bodies and list the same before the bench having roster. Huh? This matter after service of notice on the respondent. Huh? One name, So there is no compliance of the order. Huh? ಅದಕ್ಕೆ ನಿಮ್ಮನ್ನ ಕಳಿಸಿದಾರ ಅವರು. ಏನ್ ಟೈಮ್ ಕೇಳೋದು? The petitioner has not complied with the directions issued by this court. On 4/9/2023. Stop. Consequently, the interim relief given to the petitioner by order dated 4/9/2023 shall not continue. Full stop. Release this matter on 10/7/2023. Full stop. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed. Huh? You are appearing for respondent number 3. Huh? 27. Is this matter after service of notice on the respondent? Yes.
Hypothecation agreement. Vehicle is seized by us. Expedition is filed as if it is a surfacing proceedings. Contractual matter, and even the interim order is not complied.
We have now ordered the not to their office. They have refused. I paid the year. You know, not for 2 lakhs. The Honorable Court was on 18/8/2023 directed the petitioner to deposit the 2 lakhs within 2 weeks. After 2 weeks, 2 lakhs after 2 weeks. So first installment of 2 lakhs has been forwarded to TD. We are return. They have refused the same.
You have filed an IA.
Yes, my lord. Covering letter forward.
Yes. Why did you refuse to receive it?
I have no instructions, only copies served now. My lords.
They have filed an IA also.
Copies given now.
Yes.
My submission is, my lords. Yes. It's a contractual matter, my lords.
At the date of seeing the vehicle, only 1,35,000 was the outstanding balance.
See, even the proceedings initiated under the Surface Act, arrears out of contract only.
But my lords, under the action is taken under the act. My lords.
Yes.
Any statutory violation, my lords will interfere.
Yes.
Here is a matter of contract. Under the contract, I have the right to seize the vehicle. I have seized the vehicle.
Only the 3 installments. Annexure A4 page 19. Why we have not paid the 3 installments? Annexure A4 page 19. My lord. Petitioner father was in hospital for 12 days. Serious, he was very serious. Now also he is taking treatment of for stroke.
ಆಯ್ತು ನೀವು ಈ ಆರ್ಡರ್ಸ್ ಅನ್ನು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಲಿಲ್ವಲ್ಲ ಎಲ್ಲಿದೆ 6 lakhs where is 6 lakhs where is 6 lakhs sir in terms of the orders passed by this court where is the 6 lakhs
Tax has been paid. They were refused. Hence, we have paid the for that.
you are required to pay 6 lakhs. Yes.
This amount has to be received by them. Another 2 weeks time if granted, I will do deposit the amount.
Why?
We have to arrange it.
Adaito re you filed an application also. But why have you not complied with the directions issued by this court?
I am filed memo for 4 times for that. This was not posted before the court.
Why the cases to be posted for that? ನೀವ್ ಹಿಂಗ್ ಮಾಡಿದ್ರಲ್ಲ ಅದೇ ತರದ್ದು ಅದನ್ನು ಕಳಿಸಬಹುದಾಗಿತ್ತಾನೆ.
Payment ready.
Why have you not paid?
Because of this.
No.
We have no. 2 weeks.
Anyway, see, you are only interested in recovering the amount. Your interest is not in selling the vehicle. Yes.
ಏನಂದ್ರೆ ಈಗ ನಮ್ಮ ಆಫೀಸರ್ ರಿಕವರಿಗೆ ಹೋದಾಗ ಅವ್ರನ್ನೆಲ್ಲ ಕೇಸ್ ಎಲ್ಲ
ಹೌದು, ನೀವು ಆತರ ಮಾಡಿದ್ರೆ ಇನ್ನೇನಾಗುತ್ತೆ? ಯಾರಾದ್ರೂ ಕರ್ಕೊಂಡ್ ಮುಂದೆ ಒಳ್ಳೆ ಬಿಸಿ how you try to take possession of the vehicles. ನೀವು ಮಾಡೋದು ಏನು? It is on what should we say?
No, I'm not saying anything. That's my
lady.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the petitioner submits that in compliance of the directions issued by this court on 18/8/2023, when the petitioner sought to tender a demand draft for a sum of ₹2 lakhs, a demand draft dated 31/8/2023 for a sum of ₹2 lakhs. comma, the respondent did not receive it. Full stop. Therefore, the same was once again sent through registered post, RPAD, acknowledgement deed, through speed post. Full stop. The respondents have refused to receive the same. Full stop. Therefore, IA number 1 of 2023 was filed, bringing the same to the notice of this court, and while seeking a direction to the respondent to receive the same and release the vehicle. Stop. Next para. Learned counsel for the respondent seeks to submit that unlike a matter arising out of the SARFAESI Act, the transaction being contractual in nature, the writ petition filed under Article 226 of the Constitution of India should be rejected. Stop. Next para. In the considered opinion of this court, the interest of the respondent, the second and third respondent who has financed the petitioner for the purpose of acquiring a vehicle, would be in recovering the loan amount. And when an amount is tendered by the petitioner, in all fairness, the respondent should have received it. Full stop. Next para. Nevertheless, it is also seen that the petitioner has not tendered the remaining 4 lakhs in terms of the interim order passed by this court on 18/8/2023. Full stop. Learned counsel for the petitioner submits that if a week's time is granted, no sir, no. 18/8/2023. That period was over long back.
19 hospital.
Adalla, you can't make all those submissions now.
2 weeks.
If you had complied, you would have straight away directed them to hand over the vehicle. You have not complied. So therefore, we are giving you one more opportunity to comply with the directions. If you don't comply, then we will leave it to you. You go and do whatever you have to do in terms of the. No, sir.
Land counsel for the petitioner submit that if a week's time is granted.
If 2 weeks time is granted, the remaining amount of 4 lakhs will be deposited. Full stop. Next para. Release this matter on 12th of October 2023. Full stop. In the meanwhile, if the petitioner does not tender the entire 6 lakhs to the second and third respondents, the interim relief granted to the petitioner by order dated 18/8/2023 will be recalled. Full stop. At the same time, the respondents number 2 and 3 are also directed.
Only for 3 minutes. Only for 3 minutes.
ಅದೇ ತಾನೆ ನಿಮ್ದೆ ಹೆಡ್ ಆಫೀಸ್ ಅದು ಅವ್ರಿಗೇನು ಸಪರೇಟ್ ಆಗಿ ಮಾಡಕ್ಕಾಗುತ್ತಾ? Yeah, I've been noticing in many such cases, you take action in the head office sitting somewhere in Kolkata and Mumbai when the transaction has happened here in Bangalore and immovable properties are mortgaged here in Bangalore. How can you take action in the head office at Mumbai or Kolkata? How do you get the jurisdiction?
Immovable property where the property is situated.
At the same time, respondent number 2 and 3 are also directed to
receive the amounts as directed by this court at the hands of the petitioner. Full stop. Including the 2 lakhs Demand draft. Dated 31/8/2023. You can go and tender that. ಇವಾಗಲ್ಲ ಅಲ್ಲಿ ಹೋಗಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ. With the third respondent. I have directed now. They have to receive it. Yes. Interim order granted earlier stands extended till next date appearance. Learned Counsel for Petitioner has filed a memo dated 29/9/2023 seeking leave of this court to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. So accordingly, the writ petition stands dismissed as withdrawn. For submitting that some other Tenant AGA submits that she may be permitted to take notice for respondent number 2 also. Stop. Tenant AGA may file the memorandum of appearance on behalf of respondent number 2 also. Stop. A week's time is granted for furnishing the process fee for service of notice on response number 3 and 4. Same, huh? Same. The Counsel for Petitioners has filed memo dated 29/23. Why you are filing one more memo? No. Signature does not tally with the Counsel for Petition. Memo dated 4/10/2023. Seeking leave of this court to withdraw the writ petition and pursue the remedy before the contempt court. Stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn, with liberty reserved as prayed for. Huh?
Let them make application before the trial court itself, because in the similar matters, in the same matter, some applications are made for degrees of account, that applications are considered.
No. Did the police officer obtain an order at the hands of the court?
The order has been made. Now they are made as the witnesses to the cases.
I directed you to secure that instructions. Whether order was passed by the court.
The order is obtained by the judicial police station, that Varmaka police station.
Thereafter, the entire case was handed over to the COD. Now the investigation.
Where is the copy of the order? Huh?
This is the memo which I have filed on 1991, page number 2. It's only sealed as permitted.
Which means it's an order of the court. Yes. Now we will permit you, please go and file an application before the competent court and secure an order. On the previous date of hearing, this court had directed the learned AGA to secure instructions as to whether an order was secured at the hands of the learned magistrate for freezing the bank account of the petitioner. So, learned AGA submits that the concerned police officer is present before the court, and on instructions it is submitted that orders were secured, were indeed secured at the hands of the learned magistrate for freezing the bank account of the petitioner. So, in fact, the petitioner himself has furnished certain documents along with a memo dated 19/9/2023, which contains document at Annexure A, wherein the 10th learned 10th additional Chief Metropolitan Magistrate, Bengaluru, has permitted the police to proceed, by order dated 22/3/2018. Stop. Next para. Learned AGA would further submit that under similar circumstances, this court permitted the petitioners to
Respect of other accounts regarding the same matter. Respect of some other accounts, they made an application before the learned jurisdiction court. That applications are considered and
submits that in respect of the very same writ petitioner, where other accounts, bank accounts were freezed, the petitioner has made application before the learned magistrate and obtained orders in respect of the other bank accounts where such freezing orders were passed. Same crime number.
The magistrate shall record as who has submitted should be in the precise manner. Only sealed. 40 pages already.
I3 similar orders are passed. You please go and file an application. It will be the learned magistrate himself will permit you direct the freezing or defreezing of the accounts.
And AGA submit that in respect of the very same writ petitioner,
in respect of the very same transaction,
where the other bank accounts were freezed, the petitioner made application before the learned.
The concerned parties made necessary application before the learned magistrate, and the learned magistrate has passed orders defreezing the accounts. Full stop. Learned AGA would therefore submit that the petitioner may be directed to make such an application before the learned magistrate. Full stop. Next para. Placing the submission of the learned AGA on record, HEGP on record, the writ petition stands disposed of, permitting the petitioner to make necessary application before the learned magistrate in
CC number 368 of 20.
special CC number
368 of 20.
for defreezing the bank account ತಗೊಂಡ್ರಾ?
This will. Placing the submission of the learned and record, the repetition stand disposed of, permitting the petitioner to make this application before the learned magistrate in.
Learned so and so, magistrate ಬರಲ್ಲ. Principal
City Civil Session Judge CCH-1 Bangalore in special session number 368 of 2020. For replacing the bank account.
So, if such application is filed by the petitioner, the learned judge shall consider the same and pass necessary orders having regard to the other orders passed by the very same court in respect of the other accounts of other persons. Yes. Same order.
ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಮಾಡಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅದು ಸ್ವಲ್ಪ ಕ್ಲಾರಿಟಿ ಇರಲಿಲ್ಲ. Petition as well as in the main.
Pagination to be made correctly from page number 12 to 12A.
ಮಾಡಾಗಿದೆ.
ಮತ್ತೆ
ಹ್ಯಾಂಡ್ ರಿಟರ್ನ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, ಅದೇನಿಲ್ಲ. ವೆಲ್ ಎ ಅಂತ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅದು ಒಂದೇದು ಅಲ್ಲದೆ ಅದು ಆಕ್ಚುಲಿ ಕವರ್ ಶೀಟ್ ಇತ್ತು ಸ್ವಾಮಿ, ಅದನ್ನ 12 ಮಾಡಿ 13 ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Of the objection is overruled. Yes.
Your Honor, sorry, my lordship, in this case, the trial court has violated the orders of this honorable court.
Because.
Page number 59. Annexure. Document number 2. An order is passed to consider the review application filed on 15/9/2021 by the trial court. Accordingly, the earlier presiding officer said that I will consider the review. After he left and another new presiding officer took over, this order was overruled. Subsequently, there is on document number 3, another order swami, wherein this honorable court, family court is required to consider the petitioner's request for impounding of the subject documents in accordance.
Where are you reading?
So,
where are we reading?
Page number 63. The order of this court in 8093 WP. Page error last time trial birth this one. Page number. The family court is requested to consider petitioner report impounding of the subject document. The GPA produced for filing the petition.
I am not getting it. Page number 63.
How sorry? And it on 8093 WP. ಆ ಕನ್ನಡದಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದು ಮುಂಚೆ ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 3 ಡಾಕ್ಯುಮೆಂಟ್ 3 annexure.
There's a very mistake. Another repetition. This
79.
also.
Huh.
This order, this honorable court has ordered the family court to consider the impounding of the document.
He is requested to consider petitioner's request for impounding of the subject document in accordance with law.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the register of stamps and duties has already been given a suggestion that this document has to be impounded because under section 21C of Marriage Act, it's very clear that any document unstamped or not registered should not be considered. I made several IS before the family court, it was not considered. Subsequently, I approached this honorable court, which is directed to consider the review application. I've enclosed the review application also.
Where is the order? Which is the impugned order?
Impugned order dismissed, IS are dismissed, that's all. Your Honor, translated copy nalli ಇದೆ. So 13 page number. Immediately, the annexure number 1. IA number 14 and 16 are dismissed. And meanwhile, I filed a review petition on 31st August. The trial court has passed the order without even hearing anything. They passed an order and also they've directed already to pass the degree in this case. The GPA ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ page number 1 ಬಂದು which I have already produced in my earlier writ petition. Page number 1 ಬಂದು 200 ರೂಪಾಯಿ stamp paper, page 2, 3, 4 written in advocate society, page number last signed in this one Pennsylvania Philadelphia ದಲ್ಲಿ sign ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ signature ಇಲ್ಲ ಏನು ಇಲ್ಲ, ಎಲ್ಲ fraud ಮಾಡಿದ್ದಾರೆ. Several times I write this objection from the day one this petition was filed. This petition was filed subsequent to conjugal rights filed by the petitioner.
Which is that application? By which order it has been dismissed?
16464 is also order of this court.
No. Which is the impugned order? What is the date? Which application?
Dismissed ಮಾಡಿದ್ದಾರೆ 11
ಯಾವ IA
number 14 and 16. Order copy ನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. Page 5 on the inner page ಅಲ್ಲಿ
respondent filed IA number 17.
16, 17, 18, all the 4 were filed simultaneously. But order copy ನಲ್ಲಿ obtain magiಲ್ಲ.
IA number 14 to 16 are dismissed.
Ada 15 and 16 ನಲ್ಲಿ I attached the orders of this honorable court.
So where is the complete order?
Ada complete order ಬಂದು
No.
Review petition ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. Document number 1 ನಲ್ಲಿ full order copy ಇದೆ.
Illi where you have filed it here, you please point out here, sir. That is not the full order.
ಇಲ್ಲ full order ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ? There are only 4 lines there.
ಇಲ್ಲ subsequent ಇದೆ ಸ್ವಾಮಿ.
ಕೊಡಿ.
43 Lordship, one more submission can I make it? Meanwhile, the predecessor PO has said that he will consider IF as per this order of this High Court. After he left, the new PO came and he dismissed the single learned judge that dismissed that application. Idralli will be disposed of after considering on the page idralli, and his present PO has dismissed that application.
contrary of the orders of the same court.
Sir, it may have been dismissed, but we want to see what is the reasoning. It doesn't mean that it has to be allowed. The direction was to consider and pass necessary orders.
Here,
If it is considered, we want to see the reasoning. Where is the reasoning portion of it?
Kotila.
No.
Kotila, Architect Kotila Swami.
No.
No,
It can't be.
Illa Swami, Kotila. In fact, that's why I filed the review petition. Swami, subsequently, I filed the review petition, copy is enclosed before the family court. To consider these things. That review petition is also not considered, it's kept pending, and they pass the orders on the main petition.
See, you are pointing out to order dated 9/8/2023. Huh? Where is the full order? Where is the full text of the order? Please show. No. Sir, you please see it starts from somewhere on the top, only 4 lines are there. Where is the previous portion?
Previous portion
Adral illa. That is some 2022 order.
can be taken up subsequently and produced by law.
If it is there, you please point out. Let me see. Nine 2023 order.
After 9/8/2023. Number 13, I listen. That is regarding the review of application on 16424 passed by this honorable court.
14 to 16. Yes.
And already they have passed an order, judgment has passed. I have filed an application to review also in this case before the trial court.
You have not brought the notice of the learned judge that there is an order.
I have brought. That is the IAS which has been dismissed. That's why I am before your lordship. And also, she has already passed the final order. And also, I have brought to the notice of this trial court under section 21C, Swami, wherein the district registrar also has given a letter in Kannada that I have produced in this as a document number 3. Lordship, can I read it out? Kannada is on document number 4.
What happened to this petition number 8093 of 2023?
It is pending, sir.
Huh?
Order has been given, as I mentioned, that family court to consider the impound of the document under law and order. Subsequently, it is
That was an interim order.
Interim
What
order.
happened to the
After that, date for two, I mean, it was not there. It is still pending. Notice issue agide, and we have served the copies on the opposing party also. Meanwhile, Lordship, the letter from district registrar, deputy commissioner stamps and registration and clean this document is to be impounded at the section 33 and 34.
Office objection is overruled. Issue emergent notice to the respondent. Stop. The petitioner is also permitted to serve a copy of the writ petition along with annexures on the learned counsel appearing for the respondent before the second additional principal judge, Family Court, Bengaluru, in MC number 6594 of 2018. Stop. Next para. Learned counsel for the petitioner submits that the impugned order dated 9/8/2023 has been passed by the learned second additional principal judge, Family Court, Bengaluru, dismissing IAS number 14 to 16, without noticing the fact that a direction was issued by this court on 26/5/2023 in WP number 8093 of 2023 that the family court was requested to consider the petitioner's request for impounding the subject documents in accordance with law. Full stop. Tenant counsel submits that when the said order was brought to the notice of the second additional principal judge, Family Court, no submission. Where is that order?
Order 25/5/2023. Order dated 26/5 this one. Handwritten ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ ಡೇಟ್ ಹಾಕಿದ್ದಾರೆ. Handwritten page 79 ತೋರಿಸುತ್ತದೆ. ಅದ್ರ ಮೇಲ್ಗಡೆನೆ ಬರೆದಿದ್ದಾರೆ 26/5/2023.
ಇವೆಲ್ಲ ಪೇಜಿನೇಷನ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿ ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಗೆಟ್ ಎನಿಥಿಂಗ್.
ಅದಕ್ಕೆ ಕಂಟಿನ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದೆ.
ಅದಲ್ರಿ, you said the previous presiding officer noticed it and said yes, we'll have to take it into consideration. ಅದರಲ್ಲಿದೆ ಅದು.
That is on page 40.
I think 2022 ಆಗುತ್ತೆ. That order was passed in year 2023 ಅಲ್ವಾ?
8093 ಒಂದು
26
ಅದಕ್ಕೆ ಮುಂಚೆ
26/5/2023 that order was passed by this court.
Yes.
Subsequently, where have you brought it to?
Earlier to that, there was one more WP 16446 wherein it was directed to consider the review. I have enclosed that order copy also, wherein it is directed to consider on the review petition based on the same thing. When they was declined, then I approached in 8093. 8093 ಬಂದಾಗ both were there. Earlier presiding officer and the present presiding officer, both were present.
ಏನ್ ಹೇಳಿದೆ?
When counsel for the petitioner submit that when the said order was not to the notice of the second additional principal judge family court Bangalore.
In fact, you have not brought it to the notice of the family court. This order dated 26/5/2023.
Very much I brought it.
Elli, where is that? Where is it recorded? Please show. A sentence of that.
Ask you to clear.
In the.
Counsel for the petitioner submit that the impound order dated 9/8/23 has been passed by the second additional principal judge dismissing the AS number 14/16 without noticing the fact that a direction was issued by this court on 26/23 in WB number 8093/23 that the family court was requested to consider the petitioner's request for impounding the subject documents in accordance with law.
When the said order dated 26/5/2023 passed by this court was brought to the notice of the learned judge, it was noticed in the order dated another date 15/6/2023 that learned counsel for the respondent filed IA number 15 under section 14 of FC Act along with copy of order passed by registrar of stamp and also daily order sheet of this court in WP number 8093 of 2023. Stop. Nevertheless, the impugned order has been passed on the ground that similar applications were earlier filed by the petitioner herein under order 7 rule 11 and the court had already rejected such an application.
My lord, that is different. That is a review application. 16464 ಅಲ್ಲಿ order ಮಾಡಿದ್ದಾರೆ.
Stop.
This 8093 is totally different.
Learned counsel therefore submits that there is non-compliance of the directions issued by this court in the matter of reconsidering the application regarding the impounding of the document. Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings in MC number 6594 of 2018 on the file of the second additional principal judge family court, Bengaluru till the next date of hearing. ಸ್ವಲ್ಪ ಪೇಜಿನೇಷನ್ಸ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. Yes. On 7/9/2023, this court had given interim relief to the petitioner while staying the impugned order at Annexure B and all further proceedings thereto, subject to the petitioner depositing rupees 20 lakhs on or before 29/2023, with the respondent bank. Full stop. On 21/9/2023, this court found that the petitioner has failed to furnish any information showing compliance of the directions given by this court. So, however, since there was no representation for the petitioner, the matter was adjourned to 29/9/2023. So, again, at the request of the learned counsel, the matter was adjourned to this day. So, next para. Matter is called out. There is no representation for the petitioner. Full stop. There is non-compliance of the orders passed by this court while granting interim relief to the petitioner. Full stop. It was also made clear that if the petitioner does not comply with the conditions imposed by this court, the petitioner would not only be disentitled for the benefits flowing out of this orders passed by this court, but also the writ petition may be dismissed. Full stop. Next para. Consequently, the writ petition stands dismissed.
Lordships, senior counsel Dhyan Sinappa is preparing the matter kindly.
Pass over.
Lordship, yesterday I have filed the aviate.
Yesterday.
Yesterday, immediately on the very next day of the receipt of the summons by hand. It was received on Saturday. And yesterday was the immediate next working day. I have filed aviate.
Caveat.
Yeah, aviate before the passing of the order of stay. Before the order of stay is not yet passed on IA number 4. And as such being the case, I have sent the registered post of the caveat petition to the petitioners. And also it is.
When did you file the caveat petition?
Yesterday afternoon.
How can you file a caveat petition now?
No, my lord, before the passing of the order.
No. Yes.
No.
I don't know. He says he has filed a caveat petition now after receiving notice from this court. That is not permissible. Yes.
There was an amendment.
That is not permissible, sir.
Lordship.
You will have an opportunity to have your say. Where the question of you filing the caveat petition?
Your Honor, I will take up the statement of objections along with written documents in the afternoon. 90%. I'm ready with the written statement of objections. So I am with the conception that an order before passing the order of stay, caveat could be filed.
Sir, you are given an opportunity to have your say. Where the question of filing caveat now?
Already filed. I'm ready with the notice of the court. That's what. But I'm ready with the.
Sir, you are before this court. An opportunity is being given to you to raise an objection. Where the question of filing a caveat petition now? That is not permissible. You will have the opportunity to have your say in the matter before any order could be passed.
Yes, for the
Amendment, the amendment application which I filed. So if I have to objection statement, he has to deal with the amendment as well.
You have filed an amendment application.
Yes, filed an amendment application to your Lordship recollect.
Yes, because they had passed orders.
They had passed the order. Therefore, my lord, I said we must stop the work at least now because the entire procurement has been done contrary to the Public Procurement Act. And your Lordship noticed that specifically.
And now they are trying to remove all the bark and remove it. And I am not willing to even deposit to this court for more money than what he has offered. He has offered some 3 crore. I am willing to deposit 4 crores to show that if it had been projected properly to everyone, we would have all participated. There is a lot of value to this bark which is being taken away. And what has happened is they don't even publish it in the newspaper. They only publish it.
It's wrong, it's utterly wrong, Your Honor. I have come with the newspaper published with along with 30 days of 30 days given to the bidders.
Please serve a copy of the statement of, please serve a copy of the statement of objection.
Afternoon, Your Honor.
Please serve a copy of the statement of objection.
Your Honor, kindly pass over, I'll give it in another half an hour. I'm expecting one more document. In half an hour, I'll get it.
All right.
And kindly pass over you.
Perfectly. Learned counsel for the respondent submits that the
successful bidder.
For respondent number 5,
Yes.
the successful bidder submits that the statement of objections are ready,
Already.
and a copy of them same will be served on the learned counsel for petitioner either during the course of the day.
Yes.
Either during the course of the day.
Afternoon.
Full stop. Release this matter. We'll have it after tomorrow. Release this matter on 6th of October.
Published.
Yes. Huh? You have not taken steps for service of notice on respondent number 2. Today, learned counsel for the petitioner submits that steps have been taken for service of notice on respondent number 2, this morning. Will stop. Office to verify and issue notice. Yes.
The challenge with the sale notice. Sale notice has not taken place. It become infructuous. The petition become infructuous.
And prayer number 2, your prayer number is be pending for consideration. If you can prayer number, I am producing the shop.
Here prayer number 3.
For restoration possession, the third party is claiming the property. It's not permissible. They have to approach the DRT. What is the collision between the petitioner and the second respondent borrower? They have filed the suit, it came to be rejected, they have filed the appeal before the DRT, that is also dismissed. Later on, my lord, the mother has filed this petition. She has given the no objection for taking the loan. More than 3.5 crores amount due, my lord. More than 3.5 crores amount due, my lord.
So you are saying that auction did not go through.
Yes, my lord.
You will be issuing a fresh
Yes, my lord. And moreover, my lord, you have taken physical possession in the year 2022, November. 1 year back, you have taken physical possession. Now they are claiming the restoration of the building.
Learned counsel for respondent number 1. Manipal Housing Finance Syndicate Limited submits that the auction scheduled to be held on
15/9.
15/9/2023 was not successful, and therefore the prayer made in the writ petition has become infructuous. Full stop. For contra, learned counsel for the petitioner submits that there are other prayers made in the writ petition, including a direction to the respondent bank to hand over the possession to the petitioner. Full stop. How can this court pass this kind of orders, madam? Simply because you make such a prayer. Full stop. Next para. At the request of the learned counsel for petitioner, release this matter on 9th of October. Yes. No.
Property in the matter, my lord.
Yes.
In the previous date of the lord had directed respondent number 4 to ensure the petitioner be given an opportunity to given provisionally be enrolled and get a register for the AIB examination. Both of them have happened, your lordships. Been enrolled and registered for AIB.
Counsel for the petitioner submits.
Memo for
Please. Filed a memo. Dated 4/10/2023 stating that consequent to the directions issued by this court, respondent number 4 admitted the petitioner provisionally on its rolls and issued the provisional enrollment certificate. Stop. The petitioner is accordingly registered for the All India Bar Examination. Stop. The petitioner therefore seeks leave of this court to withdraw the writ petition. Stop. Next para. The memo is taken on record subject to all its exceptions. Stop. Accordingly. At this juncture, learned counsel for the respondent, Bar Council of the Karnataka State Bar Council, submits that the provisional enrollment of the petitioner was directed to be subject to the final outcome of this writ petition. Stop. It was also pointed out that the provisional enrollment of the petitioner was made subject to the verification of the documents furnished by the petitioner. Full stop. The learned counsel would therefore submit that the provisional enrollment of the petitioner should be subject to the verification of the documents produced by the petitioner. Full stop. Next para. The submissions of the learned counsel for petitioner as well as the learned counsel for the Karnataka State Bar Council are placed on record. Full stop. The writ petition is accordingly disposed of while reserving liberty to the Karnataka State Bar Council to verify the documents submitted by the petitioner and proceed in accordance with law. Yes.
That's where this law, they can hang someone, they can hang someone for not service it because of the possibility of the vacation. That's why kindly please to reissue.
Serial number 40.
Like hand someone's issue mandate, total service mandate again. That's why kindly fix a date so that I reissue.
You will only have to pay the proper process fee.
Okay.
Learned counsel submits, learned counsel for the petitioner submits that the office objections regarding the process fee paid by the petitioner for issuance of emergent notice and for hand summons will be complied during the course of the day. Full stop. If the objections are complied, notices may be issued. Yes.
Date
Baradilla. No. Yes.
Serve the copy on the other side.
I
have already served the copy on the other side.
List this matter after service of notice on response number 2 and 3.
Served me. Served.
Adal Ray, no court notice hogirodu return agadu. Yes. Yes.
Possession notice was arranged by the petitioner and now the office objection, my lord, I have sought for my car is also seized by the respondent
bank along with the machineries, my lord. So I made a prayer. Three, my lord, for release of the car also.
On complaints of office objection.
Adadale complaints again. Third prayer is for release of the vehicle also along with the machineries. Car seized madidake ena document kelidu. Along with the other machineries, the car was also seized. So that I don't have any paper in support of seizure of the car. Adike on note
Supporting documents.
Note I have written in note.
ಏನ್ ನೋಟ್ ಹಾಕಿದ್ದೀರಾ?
Note ಅದಕ್ಕೆ supporting document ಯಾವ್ದು ಇಲ್ಲ ಕಾರ್ ಸೀಸ್ ಮಾಡಿದ್ದಕ್ಕೆ ಅಂತ. Machineries, all the machineries were seized, my lord. Along with the car was also in the industrial area.
ಆಯ್ತು, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ overruled. Yes.
Now, my lord, possession notice was issued, my lord. I have filed petition, annexure D, my lord, and interim order was passed directing me to pay 20% of the amount, page number 3031. As against, my lord, I was able to pay only 10 lakhs. Then after possession notice was issued, sale notice was issued as per the annexure E. Then I approached the bank, my lord, for one-time settlement. Then my offer was accepted for 1.25 crores, my lord. And for the annexure G, annexure G, page number 38, my lord. And I had time till 31/8/2023, my lord. The offer was accepted and communicated on 27/20/23, my lord. And it was valid up to 31/8/23. So last page number 38. After item number 3, the full payment of balance OTS amount rupees 75 lakhs to be completed on or before 31/8/23. Now, immediate next annexure H, my lord. Before the expiry of date, my lord, 21/8/23, that was cancelled. I paid 10 lakhs, but
Please see the other portion, sir. ನೀವು last date ಮಾತ್ರ ಓದಿದ್ರೆ ಆಗೋದಿಲ್ಲ.
yes,
Payment of 40 lakhs to be made immediately.
as against I have paid 10 lakhs, my lord.
ಆಗೋದಿಲ್ಲ.
And now, my lord, they have taken.
Can't go on taking time after time.
I will pay 40.
No, sir.
40 lakhs, my lord, within 2 weeks, my lord. Within 2 weeks from today, I'll pay the 40 lakhs, my lord. And now, my lord, they will also kindly see annexure K. It was issued for auction of the movable properties on 21/9. On the same day, the notice was served on me, my lord.
Now again they'll come and say this OTS benefit is withdrawn.
Now
They have already cancelled it.
I am ready to pay 40 lakhs, my lord.
ಈಗ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
Now
that OTS settlement of
OTS withdrew as a way.
ಬರೋದಿಲ್ಲ.
I'll pay 40 lakhs and I'll see that it is regularized. Regularization again.
No, sir.
Otherwise, my lord, my plant and machinery and also the industrial site, which is a converted land, my lord, will be auctioned and put into trouble, my lord. Otherwise, I will pay 25% of the due, my lord, within 2 weeks from today.
No. You will not do it. We know that.
I will undertake, my lord. I will undertake before this.
Please understand that OTS settlement was done on 20th of July 2023. It was cancelled only on 21/8/2023. 1 month afterwards. ಆಗೋದಿಲ್ಲ.
And now I will
not be able to pay.
No, I will pay, my lord. I am ready to pay, my lord. I will made arrangement. 25% of the amount.
Issue emergent notice to the respondent.
My lord, otherwise, my lord, I will pay them.
Yes.
I will pay 25% of them.
No, sir.
25%.
You want to go and deposit, you go and deposit. We'll see.
No.
Yes.
Condition, my lord.
No, sir.
Otherwise, my lord, they will not accept it.
No.
And irrespective of the OTS, my lord.
No, sir.
Whatever the due that.
No, you will not be able to pay simply.
No, I will.
ಈಗಾಗಲೇ ಒಂದ್ಸರಿ ಆಗಿದೆ. We are not going to repeat that mistake again. Yes.
Objection on annexure A, which is an order sheet of the Honorable CJM Court.
Legible copy of this.
Provided. Before your lordships are borrowers. There was a total of 3 loan accounts for which there was an OTS offer, my lord, as per annexure C, my lord, for 5.5 crores. The entire loan taken was 5 crores. For three kinds of loans, a term loan, working capital, and a house.
Office objection is overruled. Yes.
So the petition before your lordships are borrowers.
Hmm.
There is an outstanding loan of 5 crores, my lord, by way of 3 loans which was obtained by the petitioner before your lordships. Petitioner 1 and 2 is a proprietorship concern, 2 is a partnership concern. There was a housing loan taken by petitioner 3 and 4. All put together, my lord, there is 5 crores of loan which is due. There was an OTS offer, my lord, made by the petitioner at Annexure C at page 33, my lord, on 8/2/2023 for 5.5 crores.
Earlier also you were before this court.
That was for the residential property. See,
Huh?
the commercial, that was for the residential property, right?
Ah.
They have auctioned it. If your lordship can kindly look at the first auction notice which was issued at Annexure G. Annexure G was relating to the residential property. Annexure G at page number 39. If the lordship can kindly look at Annexure G, which is in respect of 2 properties, which is first one is, my lord, at page number 41.
Ah.
Is the residential property, which is the subject matter of the writ petition, which we had already approached before your lordship.
Yes.
Now, item number 2, which is the commercial property, if your lordship can kindly look at the reserve price, which is 263 crores, which is 2.6 crores.
Why that was restricted
That is
only to residential premises?
Property was not sold as per this Annexure G auction notice. Now they have come up with Annexure K, which is at page number 51. If your lordship can kindly come to Annexure K. Only for the commercial property. The value, your lordship can kindly look at it. Now it is 4 crores within a span of 1 week. The property value increases from 2.6 crores to 4.5 crores. The bank itself will not increase the valuation of the commercial property, which was they wanted to sell the property in August, was valued at 2.6 crores. When they want to now sell it in October, it is automatically increased to 4 crores. The valuation itself is illegal. Well, they cannot act as a property dealer. If the value, my property is being sold at 2.5 crores 1 month before, now they increase it to 4.5 crores. What is the actual value? They have not even valued the property properly. It is a 10,000 square feet property, restaurant and lodging facility. Well, they act is so arbitrary. Can the bank come up with 2 kinds of valuation? One at 2 crores they want to sell. Subsequently, they say that I want to sell it at 4 crores. What is the actual value? I have also made a OTS proposal which was accepted as per Annexure D. They said we are accepting the OTS proposal.
Madam, you have to go before the DRT. These matters cannot be considered here.
The lordships have already granted us some protection.
Why you restricted your earlier writ petition only for to the residential property and
commercial property was not sold. I was before your lordship seeking for protection for the residential property. So that was sold. The lordship granted protection that no sale did be executed vis-a-vis the residential property. Now the commercial property is being put to sale at an enhanced rate, which is drastically different from what they want to sell.
It is in your interest.
Yes. It can't be such arbitrary action. Is what I'm bringing to your lordship's notice. That 4.5 crores, there is a difference of 2 crores from 10 days to 10 days prior to the.
But that is in your interest. Yes.
But can it be so arbitrary? Deposit some kind of some amount. You will actually kindly look at Annexure D, which is an acceptance by them for the my OTS. But Annexure D is the acceptance. Annexure E is wherein they communicate that you pay 5.5 crores in 1 day, based on which your lordships had also earlier granted us interim order. 1 day is what is given to me for paying the 5 crores amount. I have paid already 50 lakhs.
No. You yourself had submitted that in respect of the commercial properties, earlier you had filed a writ petition.
Please, that has writ petition has become infructuous is what I am told by briefing. Now they have put they're putting it for sale second time by valuing the property at this, which your lordships are rightly pointing out is in my favor. But the arbitrary action is what I'm questioning. The bank's arbitrary action is what I'm questioning. But also the earlier auction ballot, which is at Annexure D, says 9 crores is due. They sell the residential property for 2.5 crores.
Where have you mentioned regarding the previous petition?
But we have also produced the previous copy of the previous writ petition at Annexure B, page 20, which is relating to the commercial property, which was granted earlier in the month of November 2022. There was a dispute relating to the entire amount. The amount is in dispute. Now the OTS is 5.5 crores. I am ready to comply with that OTS offer, my lord, 5.5 crores, and I have paid 50 lakhs also.
No, but why have you not mentioned it in the memorandum of petition?
Sir, it is mentioned, my lord. Actually, this is what I have produced.
Where have you mentioned in the memorandum of petition?
But it's at page number 7, paragraph number 7. Page 8. On 30/11/2022, and annexure B is the copy of the entry. Then, my lord, post to that interim order, my lord, there was this OTS facility which was offered to me. Because the order of this honorable court is in the month of November. In February, I make an offer to the bank. Bank accepts my offer on 28/3/2022.
When is the auction scheduled to be held?
On 5/10, my lord, that is tomorrow.
My lord, I have one submission in this matter. I filed a KVT. My lord, I pray for my lord respondent. I filed a KVT.
Yes.
My lord, it is a matter,
Yes.
my lord, earlier petition number 20387 of 2023. My lord,
Yes,
they
yes.
made a wrong submission before this report and they obtained an interim order. My lord, what has happened in this matter, my lord? They made a submission before this honorable court stating that, my lord, 50 lakh they paid. And pursuant to that, my lord, the bank given 1 day time to, my lord, pay the entire OTS amount. Therefore, they are not able to comply. That was the case made before this honorable court. It is
Yes.
not so, my lord. In fact, the petitioner made a submission before the bank. In fact, he given a letter which I produced with my statement of objection to the other matter, the 20387. In fact, he requested, I will pay the entire OTS within 1 day. That is his request, my lord. I placed it before this honorable court in another petition. My lord, kindly have the matter along with this matter tomorrow. I'll place all the documents before this honorable court. My lord, my outstanding as on today, my lord, 9.5 crore. The OTS given for limited period. He is not compliant the OTS.
This matter, along with the WP number.
20387 2023, my lord.
23878 of 2020.
20387. 2038.
Annexure J, my lord.
What is this 2387?
That's the earlier petition, my lord. What my learned friend is referring to is annexure J, which is the petition number 20387.
Where have you mentioned about that petition here?
Annexure J. That is also mentioned, my lord, at para 14.
14.
Please.
20387 of 2023.
Please.
Tomorrow. From tomorrow will be taken up for preliminary hearing. It will be taken up for. It's all right, madam. Previously also, we did not stop them from proceeding. Let us see. Yes. Not now, not 2:30.
Legal urgency.
ಸ್ವಲ್ಪ ಅಲ್ಲಲ್ಲ ಅವಿನ್ನೇನ ಹಾಕ್ತಿದೀವಿ ನಮ್ಮ ಕೊಡ್ತಾ ಇದೀವಿ ಪೋಸ್ಟ್ ಹೋಗಿರ್ತಾ ಇಲ್ಲಿಂದ ಪೋಸ್ಟ್ ಆಗ್ತಿಲ್ಲ ಅಲ್ಲೋದ್ರಲ್ಲಿ ನಿಲ್ಸ್ಕೊಂಡ್ರಲ್ಲ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿ ಅಂದ್ರು ಡೈರೆಕ್ಟರ್ ಅರವಿಂದ್ ಭಟ್ ಮಾಡಿರುತ್ತಲ್ಲ ಅದೇ ನಡೆಯುತ್ತಾ? ನಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 45 ಇತ್ತು ಸರ್, ರೀಚ್ ಆಗಲ್ಲ. 45. Next.
Advocate Anand ಇದ್ದಾರಾ?
Court officer. Court officer. Court officer. Sir, 230 list ತಗೋತೀರಲ್ಲ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರಾ? Okay, sir. Thank you.
That's it. That's all. Element 61. 31. Not issue.
Huh?
It's 61.1.
Huh?
Day after tomorrow.
Yara? Huh?
You have that.
Please wait. Yes.
Of PR picked up in the taken on 11th. 46 minutes.
Ordered.
Yes, in the effect of PR. Taken on Monday at 11.
Who's on the other side?
Yes. I am for the petition in the first matter and
Serial number 46 at the request of
petitioner.
Tenant Council for petitioners. WP number 9136 of 2020. Release this matter on 11th of October. All right. Yes.
Renewal of passport ballot.
Huh?
Renewal of passport ballot is start for this renewal of passport ballot. Last week ಬಂದಿತ್ತು ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀವಿ ಇವರು ಸೆಂಟರ್ ಗೌರ್ಮೆಂಟ್ ಮತ್ತೆ ರೀಚ್ ಆಗಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಇವತ್ತು
ಕೊಡಿ. So what should I do? You will have to wait for your turn. You please wait. If you make this kind of a submission, I'll not be able to help you. There are parted matters. We have to conclude that. Without concluding, I will not be able to take up new matters. Yes, you'll have to wait. Yes. Who's on the other side?
I appear for the C to 5.
Yes. Any objection? Serial number 47. At the request of learned counsel for the petitioner in WP number 15648 of 2021, release this matter. All right. On 10th of October. Yes. Yes. 11th. All right.
Patient. Number 44. Karnataka BG.
Yes.
Okay. The trust, my lord, there is no incorporation. Therefore, I make a proposition, my lord, for your lordship to consider.
All right. Office objection is overruled. Yes.
Petitioner before your lordship, my lord, is one of the bidders for a tender. It was initially rejected, my lord. Thereafter, an appeal was filed before the appellate authority. The appellate authority admitted the appeal and directed the case of the petitioner to be placed before the concerned committee. Your lordship will find that at Annexure A, page 24. Lordship will find the operative portion at the foot of the page.
Yes.
Appeal of the PIA is admitted. So it is directed to place training proposal of appellate before appropriate authority in the next PAC. My lords, thereafter the meeting was convened at Annexure B, my lords, page 26. This is the meeting of the PAC. Your lordship will find the agenda at page 28. Case of the petitioner is at item number 3. Thereafter, my lords, the meeting is preponed from 18th July at 12:30 to 18th July at 11:45. Over the page at page 30, your lordship will find the participants in the meeting. Here they don't give me this notice. Page 30. Petitioner's name is not there. Similarly, page 27, petitioner's name is there.
It was preponed.
Please, my lords.
And you were not informed.
Then the meeting goes ahead at page 31. They consider the case of the other bidders. My case is not put up. Thereafter, I made 3 representations. Not considered. Now what has happened is, whatever targets I was supposed to meet under the bid, under the tender, they reallocated it to other bidders and they issued that at Annexure F without considering me.
What is tender about?
The tender is for skill development, Manoj.
Ah.
Under a central government scheme, these bidders are supposed to establish a training center, and each of them are given a certain number of candidates they have to train. This is for skill development. I'm already doing the same work for Kerala, for Karnataka and Arunachal Pradesh, Manoj. When it came to the state of Karnataka, I bid. I was rejected. Thereafter, the appellate authority asked my case to be considered by the PAC. PAC, without considering my case in spite of the appellate order, devises the targets to give it to other people who are qualified. I see at page 34 and 35, my lords. At the proceedings of the meeting. Page 34, entity number 3. The lordships will see initially 300 candidates they were supposed to train. In this meeting at page 35, bullet point number 3, their target is enhanced to 700. Similarly, my lords, for the second one, that item number 4, the Deepika Academy so and so, their target is also enhanced. As a result of which now they don't consider my case. I'm only asking for an opportunity to be considered, my lords. Although an appellate authority order is in my favor, they don't place me for consideration.
Yes. Any instructions? Order. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures and the learned AGA. We'll stop. Next. Learned counsel for the petitioner, trust, submits that on an appeal filed by the petitioner before the principal secretary, Government of Karnataka, Skill Development, Entrepreneurship and Livelihood Department, a government order dated 21/6/2023 was passed at Annexure A admitting the appeal while directing
That item is responding to
respondent number 2 herein to place the training proposal of the petitioner herein before the appropriate authority in the next
PHC, that's respondent number 3, project approval committee.
in the next project approval committee meeting. Stop. Learned counsel submits that a meeting notice dated 13/7/2023 was issued by the second respondent. This was issued to you?
Please, my lord, it was at item 18 over the page 27.
You didn't attend the meeting that day?
My lord, that day, this was a meeting for 18th at 12:30. The meeting was preponed to 18th at 11:45. I didn't attend that preponed meeting because it was not notified to me. Lordships will find at page 26. The date of the meeting is 18th July.
Same date is same.
Please, my lord, date is same, it's just brought forward in terms of timing. But that is not issued to me. That your lordships will find at page 30. Page 30, your lordship saw 27. Serial number 18 was me. Here 18 office copy guard file is not given to me.
No, at least, but did you go there at 12:30?
I don't know about that, but this was not given to me. I did not know the meeting was preponed. Kindly see the.
That's all right, but you received the meeting notice, which was scheduled to be held at 12:30 on 18/7. Did you not go at 12:30 at least?
So that
Another?
the agenda is there also is not considered. At the meeting, what exactly happened?
The council submits that the interim notice dated 13/7/2023 was issued by the second respondent.
Scheduling the meeting to be held at 12:30 PM on 18/7/2023. So, however, it appears that the meeting was preponed and held at 11:45 AM, for which there was no intimation to the petitioner. Stop. Learned Counsel submits that the meeting has proceeded without the presence of the petitioner, and allocation of the works have happened without allotment to the petitioner. Stop. Learned Counsel would further submit that some of the targets which were earlier fixed have been enhanced and given to certain other entities. Stop.
That's not the petition of your lordship. But Karma is a different bidder. It's not me. The petitioner before your lordship.
Stop. Learned Counsel would therefore submit that there is still scope for the second respondent to reconsider the allocation of the works and make provision for the petitioner trust also, which has got huge experience in the field. Full stop. Next para. Release this matter on 9th of October 2023. Full stop. Learned AGA is directed to secure instructions and make submissions. Yes. Let us see. Yes. Huh? Certified copy of washing annexure to be filed.
The e-tender notification. Downloading the
Huh?
e-tender notification.
Downloading
the notifications. It is only with regard to the eligibility criteria. The deadline for submitting the applications is only.
Office objection is overruled. Yes.
The eligibility criteria for applying the tender. The previous tender for 341 lakhs. Now it is enhanced to double. If it is enhanced to double, that
Providing catering services for Indra canteen.
The previous law in Harassment it was 341 lakhs. But now it has enhanced to 742. Double the amount it has been made. So therefore, that the considered eligibility criteria for the past 1 year it was earlier considered. Now for the project for the past 2 years, financial years, now they are considering. So in such a situation, the petitions like the person who are interested will be declared that only the criteria. It is,
No, you are yourself saying it will be for 2 years now.
Yes.
So it is as good as the previous one.
The application.
ನೀವು ಎರಡು ವರ್ಷ ಸೇರಿಸಿದ್ರೆ it will come to that.
The application received of yesterday. But what happens that it is open that the matter is registered on day after tomorrow or Monday, I will get whether my application is considered or not. I can make
Learned AGA takes notice for both the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures from the learned AGA. Really, it matter on 9th of October. All right.
Other matter.
Yes.
Yes, Lord. The respond number 1 is a recovery of somebody to the respondent number 2. It's sufficiency against the petitioner. The innocent brand. They purchase the flat with the respond number 7. The selected matters before the honorable court. Not this liability 15189 of 2020, we already stay granted. Number 2 itself given NOC to the petitioners even after they clean the surface.
Please see respond number 9. I think there is a mistake in the name. Please correct it. Vinayaka ಅನ್ನೋ ಬದಲು ಐ ಹೋಗ್ಬಿಟ್ಟಿದೆ. Please do it now itself. Whatever. Issue emergent notice to all the respondents. Next, learned counsel for the petitioner submits that under similar circumstances in WP number 11740 of 2023, by order dated 8/9/2023, this court accepted the submission of the learned counsel for the petitioners that the petitioners are agreement holders bar buyers of individual flats. Stop. When several such flat buyers approached this court stating that they have been paying the loan amount having been assigned with the loan that was originally obtained by the builders, this court had passed interim orders of stay, including in WP number 10412/2023 and 10553 of 2023. Stop. Learned counsel prays for similar orders. Stop. Next para. Consequently, there shall be an ad interim order of stay as prayed for, and all further proceedings pursuant to the impugned order dated Annexure F. Order dated 21/3/2023 at Annexure F till the next date of hearing. Will stop. List this matter along with WP number 10412 of 2023. Yes, same orders in 2 also, serial number 2. The annexure date of next one. Same date. Yes.
Number 3.
Yes. Yes. You will continue. What do you want to know? To issue Hakkupatra, local bodies matter.
On 2019 and 6/6/2023, my lord. Petitioners belonging to the working as a rickshaw drivers.
Ashraya scheme. Under the Ashraya scheme, matter pertains to the local bodies roster. So, office is directed to reclassify the matter as local bodies and place the matter before the bench having roster.
The bank. But it appears that 2011 overdraft facilities were taken. Petitioner has appended signatures to the guarantee. But subsequently, he refused to continue it in 2017. What has happened is the principal debtor, who is one of my relatives, he has forged my signatures and continued the guarantee. Comrade, for example, can you see page number 67? 69, sorry. This is the forced guarantee. 69 bottom. Rajeshwari and Jaikumar, those two signatures. Rajkumari and Jaikumar. They are the guarantors. I did not take the loan, but I was a guarantee to this with my agricultural properties. Now, can you see page 161 and 162? Signature of Jaikumar and Rajkumar. The Wakala.
Now, see, how do you expect this court to consider all this?
Yes, but all that I see, since there is fraud, and these are all agricultural properties. They are not-
Therefore, you should have gone before the bank.
Yes, but I filed a criminal case, FIR is lodged. Now, but I'll have to file a suit. Properly file a suit and send the bank.
No, did you give a representation first of all to the bank? Where is the representation?
Document number. I filed a FIR also. Blood, page 91. Page 91 is our legal notice. To the branch manager, Lakshmi Vilas Bank. Legal notice issuing for forging the signatures of Jaikumar.
August 2021.
Yes.
ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ we filed an FIR page 134. As a complaint.
They did not respond.
They did not respond. Page 139 is the complaint, 134 is the FIR. 39 is the complaint. The station house officer Sadashiva station on 10th May 2020. Based on which an FIR is lodged. Unfortunately, police also have not sent it for forensic verification. Even after the 90 days to file charge sheet, before 90 days to file charge sheet, and police also kept it pending. And they have lodged the FIR and kept the investigation standstill. What the offense is under section 468, 406 and 420. And they have not moved the investigation. Therefore, I have made the bank also as the accused persons. And of course, because I have
Annexure U.
Annexure U.
Page number?
Page Annexure R, page 134.
Annexure U is page number?
Page number
156.
156. Yes. That is option. No doubt, I'll have to file a suit to get over these transactions. I'll require 4 weeks to, because parties are in Chennai. 56 is the option.
Immovable property?
All these properties are agricultural properties.
No, but if you say you refuse to continue as guarantor.
Yes.
Did you take back your property that was mortgaged?
So what had happened was that explanation is there in the complaint. What had happened was the principal debtor had assured me. He was one of my relatives. He had assured me that he will bring back these papers.
No.
And he said that these papers are with him. That I have stated in the complaint at page 150. Can you see? Page 143.
All becomes disputed question. We cannot go into all these aspects.
But what I will request about is I will file a suit, comprehensive suit, challenging the continuation of guarantee to the wording. Till then, my lord, because tomorrow is the auction. Till then, let them not conduct the auction. Let the trial court take a decision.
No, not at this stage, sir. At least when you received the notice, if you had immediately come, you would have done something. When the auction is scheduled to be held tomorrow, how can we stop it?
But notice came recently. The auction notice. 28th they have published. 28th of August. The auction notice. And Lord, all of these are
The
agriculture.
very fact that you are not able to take back your property that was offered as a collateral security shows that you have been party to this proceeding.
What happened was, at that point of time, these are my relatives, instigators. Since I refused to sign the signatures, they assured me that they will get back the students. And somehow, since they were relatives, we agreed. We have kept quiet. Perhaps we have kept quiet. All these properties are agricultural properties in Chittoor. They are not even converted lands. And agricultural properties, there is a bar under the land. Against auctioning agricultural properties. Is to that extent.
That will be a conflicting argument. If you say agricultural property could not have been taken as a security, that's a different aspect. That will be on the merits of the matter.
Now, Lord, since there is fraud, I will have to assign these transactions on the basis of the fraud.
Yes.
But I would also say that to show some bona fides, I would deposit some amount of money in the court.
Why do you want to deposit?
Yes, but I have to save these properties. Or at least I will seek an injunction before the trial court. Till then, the auction may be stayed. I am giving.
No, we'll only say that auction shall not be confirmed, sale shall not be confirmed till they appear. And by the meantime, you take whatever action you want to take.
Auction
No,
occurs.
we cannot stop the auction that is scheduled to be held tomorrow. Not possible. We will say that they will not confirm the sale till the next date of hearing. Berkeley. Learned AGA takes notice for respondent number 6. You want to appear for bank. Learned counsel Shri Yogesh Kumar. Yogesh Kumar. Yogesh Kumar. Yogisha Kumar. Undertakes to file wakalat for respondent number 1. Submits that he had in fact filed a caveat petition on behalf of respondent number 1. And he has received a copy of the petition also. But his name is not shown in the cause list today. Full stop. Issue emergent notice to response number 2 to 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned senior counsel Shri Vivek Subbareddy, appearing for the petitioner, submits that. What are your instructions when they issued the notice to you? What did you do? You have replied. You have replied.
And the petitioner also directors of the second respondent. They are 58% share in the second respondent. Okay.
So even otherwise,
Only guarantor. They are the directors.
Non-participating directors. Non-participating directors.
Learned senior counsel Shri Vivek Subbareddy, appearing for the petitioner, submits that although it is not disputed that the petitioners had initially stood as guarantors to the loan secured by respondents number 2 to 5 from respondent number 1 bank. Nevertheless, subsequently, for the subsequent years, they declined to continue as guarantors. Stop. However, their signatures were forged and the transaction continued with the first respondent bank. Stop. Learned Senior Counsel submits that in this regard, a legal notice was got issued by the petitioners to the first respondent bank on 2nd of August 2021 at Annexure J, but there was no reply from the first respondent bank. Further, a complaint was lodged by the petitioners in the matter of their signatures being forged at the hands of the contesting respondents herein, and an FIR has been registered before the 4th Additional Chief Metropolitan Magistrate, Bangalore City in crime number 0071 of 2022 by the Sadashivnagar Police Station, Sadashivnagar Police. Stop. The Senate Council submits that if the auction which is scheduled to be held tomorrow is not prevented, the petitioners will be losing their valuable property, immovable properties, which are also agricultural in nature. We'll stop. Next para. For contra, Learned Counsel for respond number 1 bank submits that a reply has been caused by the first respondent bank to the legal notice issued by the petitioners. ಅವರೇ ಹಾಕಿದಾರ ಅದಲ್ಲ ನಿಮ್ಮ ರಿಪ್ಲೈ 101 ಹಂಗಾರ ಮೇಲ್ಗಡೆ ಇರೋ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದುಬಿಟ್ಟೆ ಅವ್ರು ದೇ ಹ್ಯಾವ್ ನಾಟ್ ರಿಪ್ಲೈಡ್ ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬಂತಲ್ಲ ಅದು ತೆಗೆದ್ಬಿಡಿ ಅದು
They are saying from 2017 they have not extension of like 4 years.
Reply dated 10/8/2021 caused to the legal notice which was issued to the petitioners. So, the Learned Counsel would further submit that the petitioners are not only guarantors, they are also directors of the second respondent company, which has availed the loan facility from the first respondent bank. We'll stop. Learned Counsel would submit on instructions that the amount outstanding receivable by respondent number 2 and the directors of the company is more than 11 crores. Stop. Next para. At this juncture, Learned Senior Counsel Shri Vivek Subbareddy would submit that the petitioners will have to approach the competent civil court to get a declaration in the matter of their signatures being forged and the immovable properties belonging to the petitioners being put up for auction at the hands of respondent number 1 bank. We'll stop. However, it is submitted that till then the first respondent bank may be directed not to confirm the sale, if the sale goes through tomorrow. Full stop. Next para. Alla bekagilla. We are permitting you to go ahead. We are not stopping you. Consequently, the first respondent bank is permitted to go ahead with the auction that is scheduled to be held tomorrow. Full stop. However, till the next date of hearing, the sale shall not be confirmed. Full stop. In the meanwhile, the petitioners may approach the competent civil court and get any interim order which would protect their interest. Full stop. Next para. Release this matter.
More relief that the police have to submit the final.
Hmm?
Hard case. Forgery case. The police have kept it pending since 1 year.
Plus, this will definitely be in the nature of a civil litigation. So the orders that kind of a direction regarding whether the signature is genuine or not can be considered by the civil court while issuing appropriate directions to send it for expert opinion.
The police have to file the status report at least. They are not moving the investigation because bank isn't.
That is because, see, there is a circular issued by the state government and the DG and IG that in civil matters, these kind of complaints should not be received and they should not proceed in the matters. That is why I think they are keeping quiet.
But at least let them come and say that this is the position. They are just
No. Now that you go before the civil court, you make the application and let it be sent for expert's opinion. Ultimately, it is the civil court that has to decide. The police will not be able to decide this issue.
If there is real forgery, what the police usually do is they send it to forensic on the basis of which they proceed.
Allah, adikkene, see, when these are all matters in the civil nature, they are directed not to enter into this list. Release this matter on 13th of October. Yes.
ಅದು ಇದು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿದ್ರೆ ಆಫ್ಟರ್ ದಸರಾ ಇರಬೇಕು.
ಆಯ್ತು. 26th of October. All right. Where is the SPP? Where is the SPP? Huh? This is the type of attitude. This court is not going to take it. This is not the way. Oh yes, you can go on. Yes.
I'm concerned about the contesting respondent in first case where the senior counsel is representing, and the second case where I'm the petitioner.
No, sir. Please go on, sir.
How is it for me?
I am not going to say anything now. You please wait till he concludes the argument. Yes. Yes. Huh? Huh. Where is it? Please give it here. That is only about one girl. There are other statements also. There are other statements also recorded. Yes. 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 Huh? You have heard the learned senior counsel arguing. He has contended on the basis of the written complaint whether the ingredients of the offences quoted by the police is made out. On a plain reading of the complaint, it says the two persons who took the who filed the complaint initially was on the basis of a wrong information. Look at the type of offences that are now sought to be made out in the FIR and in the charge sheet. Does the complaint make out the ingredients of those offences? And can you proceed in this kind of a matter where there are serious allegations made against some person and that criminal case is going on? Is it not an attempt to derail the criminal process system? You yourself have registered the case and the case is going on against that person. And unless, as it was pointed out, the court comes to the conclusion that a false information is given, false evidence is given, and therefore, if that case is acquitted and there is a direction given by that court to take action against the persons who are responsible for initiating this criminal action, how can you jump to a conclusion that they have given a false information? How can you now come to a conclusion that there is wrong information given? It is not only about one child. Now probably the statement of many other students from the hostel has been recorded. So unless the trial is held, the court comes to the conclusion, no, there is no truth in the allegation made against the accused person therein. What investigation can you make at this stage on the basis of the complaint given by this complainant? You please read what is the complaint. Does it make out any ingredient of the offences that are cited in the FIR and in the charge sheet? Where that complaint? Where is the complaint? 18. Yes. 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 So the allegation is conspiracy, trying to extract money. How does this provisions under 366A, 384, 420 come into the picture? See, you should understand before taking any action that this is a complaint made in respect of another complaint that is already registered before you, and you have taken action in accordance with law. The matter is now pending trial. At this stage, how can you come to a conclusion that the information given is false? Just because this person says I overheard something in the social media. How can you investigate into that matter now? Unless there is a direction given in the other case to find out the truth of the allegation. This allegation can be made by the accused person there. These are all false allegations made against me. I have information that this is the recording, voice recording that is that was forwarded in the social media. So that is something that the court can go into. It directly affects the case already pending before the court. How can you investigate into that matter and try to find out whether the information given to you and which is recorded by you, a report is registered, a criminal case is registered, which is converted into a criminal case now, and the trial is about to commence, or it has already commenced, about to commence. Is it not? Would it not amount to derailing the process of criminal justice? Are you not required to protect the witnesses under the Witness Protection Act? And it has been pointed out that having regard to the allegation made, where it is plain and clear that a false information was given against another person, by virtue of which a criminal action is initiated against that person. If you read it plain and simple, these are not the provisions that are attracted. The other provisions that are really attracted is 177, 182, for which information will have to be given by the officer concerned under section 195 of the CRPC. How can you jump the gun and you try to investigate whether there is any truth in the allegation? How can you go into all that aspect now? It was also pointed out that these information that are collected can form a part of the other case also. It can be placed before the court. As a counter blast, can you register one more case? That too not at the instance of the accused person. Now there's some other person who is given a complaint. All right, you may make whatever submissions you want to make. I consider. Huh? Yeah. There is only one child. How many such students have given the complaint or given their statement? Only one. She was the only one. No, but in that statement itself, she has said, my mother and my elder sister. No. You please read that one. Where does he say that there is no truth in the allegation made? Huh? I thought. Where does he say that there is no truth in the allegation? Have you produced a copy of the complaint given in the original complaint? Not this case, the original case.
445.
Ah. Where is that? Where is that?
Is 45 complaint about the. First petition.
Page number 162. Page number 116, huh?
Today. Here, my lord, registered under 445.
Ah.
For 2002, which was corresponding to 182. 182, my lord, FIR. 182, my lord, was Hyderabad police station. That was the original. Finally, page 58, my lord, petition. First part, my lord, section G. March by Gayatri. Mother.
58.
58, relevant page 63. 58 is the FIR.
Ah.
Lord, page 63 is the complaint. Part of the petition. Akshat Nirakshar, Nazarbad police station. Gayatri PV. Vishalakshi Nagaraj.
This is the mother of that child?
Mother of that child.
Yes.
There are two children, there are two daughters of this lady, my lord.
Both of them are studying in the same.
Yes.
Yes.
And they were residing in the hostel, Akka Mahadevi hostel, my lord, maintained at this part. They were residing there.
Yes.
They have been issued. My lord, they have largely complied. Plus, my lord, their name, my lord, is. This complaint is very clear. The head note is. Lord, Nanna Ibbaru Makalada.
Ah, you don't have to repeat the name.
Yes.
Yes. So it's not only one child. Just on the basis of even if it is true. Correct. See? Yes. Correct. No. See, please understand. That is why I'm asking. the original complaint against that accused person is not only in respect of one child. There are any number of names mentioned here. So just because one of that child has given some sort of a statement, would it be applicable to all the others? Then maybe in respect of that child, it may not have happened. But what about the others?
But the conversation, my lord, was that child was asked to do complaint. It was not a do false complaint. This is very important. They are saying, my lord, that one of the teacher has persuaded that girl, you have been misused like this. Go and give a complaint. Why can't you give a complaint like that? That was the conversation. He has not persuaded that girl that I want to marry you and you give a false complaint against Swamiji. That is not. No, this is going on since a long time against girls. Why can't you lodge a complaint? No, that is what he has suggested. He has not persuaded that girl to give a false complaint. And in 164 statement, the girl doesn't say that I gave a false complaint against the party of the man. I had a conversation with the teacher. Now, ಈಗ ನನಗೆ ಧೈರ್ಯ ಬಂದು ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಡೆದಿದ್ದೆಲ್ಲ ಈಗ ನನಗೆ ಧೈರ್ಯ ಬಂದು
That's why I said that she does not deny. She does not say that the complaint given me was false. ಆತರ ಏನು ಹೇಳಿಲ್ಲ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ಕೂಡ. ಇವಾಗ ನೀವು ಓದಿದ್ದು ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಕಂಪ್ಲೀಟ್ ಅದನ್ನ ಟ್ರಾನ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ದಾರೆ. ವೇರ್ ಇಸ್ ದಟ್? Huh? See? Go to the IPC code. See? Yes. Knowingly that it is likely that she will be forced or seduced to illicit intercourse with another person. That is not the provision. The provision says, whoever by any means whatsoever induces any minor girl under the age of 18 years to go from one place to go from any place or to do any act with intent that such girl may be, or knowingly that it is likely that she will be forced or seduced to illicit intercourse with another person, shall be punishable with imprisonment. ಎಲ್ಲಿ ಅಟ್ಯಾಕ್ ಆಗುತ್ತೆ ಈ ಪ್ರಾವಿಷನ್? The content is that he has forced her to give a false information or make a false statement that this person has seduced me or he has made use of me. That is an incident that has already taken place. How does this provision get attracted in this case, in this complaint? It is a clear statement that the original information that was given, complaint that was given, was based on a false information. Now that girl is trying to retract that statement. So at best, it can be that she has admitted that she has given a false statement. But ನೀವು ಹೆಂಗೆ ಹುಡುಕಿದ್ರು 368A ಅಟ್ರಾಕ್ಟ್ ಆಗದೇ ಇಲ್ಲ ಈ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಲ್ಲಿ. Not possible. Yes. $420 has been given up, is it? Yes. 420 has been given up. What has been retained? 366A, 384.
120B, 201.
388.
120B, 384.
384.
Not one is added. Beginning of offense.
384 or 388? Punishment for extortion. So again, the allegation, now that is sought to be imputed. So he has used that word that by giving a false information, he is trying to extract money. That is pertaining to the original complaint. So whether it is true or not, whether he has made use or is given a false information to extract money is a case pertaining to that complaint, the original complaint. How can that be tested in this complaint? That is why the submission is, after the trial is held, if the court comes to the conclusion that this person has given a false information, so you proceed against him. There is no there is no way the police can now start investigating into this matter, this complaint now, because it will become part of the transaction or part of the proceedings in that case. The truth will come out only after the trial is held and the court gives that verdict that this person is guilty of giving false information. So proceed against him. That is why it was said that in terms of section 195 of the CRPC, it is the officer alone who can lodge the complaint. That is after the verdict is given. If the court feels, yes, there is something to proceed against the person on whose instance the case was registered against the accused person, there is no occasion for the police to now start an investigation into the matter. Okay, that's your submission. Yes.
Available, the senior counsel, he's instructed me to request before this court.
Huh?
So Monday and Tuesday.
Sufficient time, my lord, is given already.
Huh? ಅದು ಇನಿಷಿಯಲ್ ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ. You said that.
Yes, my lord. Connected repetition, my lord, it is for a direction to conduct investigation.
Correct.
Not by chance it is.
Correct. That's all right. He had made the statement, but I've kept it so that in the final decision, both the matters can be disposed of.
My submission, my lord, it is since 2 weeks before your lordship is heard. It may not be, my lord, at best, my lord, tomorrow returns it is being, my lord, it is starts like this.
You didn't furnish any decision on this section 195.
I have given the 62
195 da.
directly on the same point. 182 offense, my lord, it is alleged. Is Dawlatram, my lord, Nashima Kindness, directly on that point. Page,
Judgments put in.
yes, 213. Two decisions, my lord.
Dawlatram,
my lord, page 213, my lord, and of this court, my lord, a Tahsildar has to file a complaint and one read it. That the Dawlatram's case, my lord, Supreme Court, for offense of 182, a complaint in writing only maintainable. Yes, 213. 182. Tahsildar may not has to lodge the complaint. And paragraph 4, my lord, it is 214, my lord. Paragraph 3, my lord, page 214. Also the offense, my lord, 182. In false information, Tahsildar corruption committed in the it was found to be false. Petition is at the time when the complaint was lodged, he was knowing fully well that it was a false information. Direct last paragraph in the last part it is mandatory it is but a charge sheet was put in by the state officer. The concept for state government did not comply. In our opinion, this is not due compliance. The cognizance of the case was therefore wrongly assumed to the court without the complaint in writing. How the public servant named the Tahsildar in this case. The trial was without jurisdiction ab initio. In this case, he was found guilty upon a on the basis of a charge sheet filed for offence under 182. Trial was conducted. He was found guilty.
But only because there was no complaint in writing by the competent authority.
Did not file charge sheet. There was no complaint of the Tahsildar to initiate proceeding for the offence under 182. Supreme Court has said that this is mandatory. It does not give a jurisdiction. In this case also, registration of FIR touches the point of jurisdiction. Police have no jurisdiction to register FIR in respect of these allegations. This is exclusively for the court which tries original matter. Found it, yes, in this case, the complainant who is examined before the court, not only while lodging information to the police, but also in court he has given false evidence. I found out the accused are innocent upon the false information given. Therefore, it is required that the complainant should be prosecuted for offence under 182 or 177. Upon such a recommendation in the judgment, the ministerial officer has to initiate the proceeding on behalf of the court. That is, police have usurped power, which is the most abuse of power. There is no any then accused also will make one complaint. The victim also will make complaint. On the basis of accused against the victim, two parallel proceedings running is unfortunate. Basically, it is magistrate would have prevented him when he issued the FIR.
That is why it said the courts should be the first line of defense. The court should have taken note of this. And unfortunately, that has not happened.
The conversation was with one Basurajendra, who was the teacher, and that girl. These petitioners have not played any role. These petitioners have not played any role in persuading that girl. The girl was persuaded to give a complaint, not that to give false complaint, but that Basurajendra Devuru.
Correct. That is another aspect of it.
Another person, not these petitioners. These petitioners overnight have been lifted and produced before the magistrate. Then the counsel was pleading, sir, you require please don't remand and still magistrate remands. But these kind of injustice will not in this case. Right from the stage of lodging of complaint, registration of FIR, arrest, production, Then continuation, my lord, here filing of writ petition itself is an abuse of procedure. Second writ petition, my lord, seeking direction for the investigation by effective officer, which cannot be done because FIR itself is not made. This continuously, my lord, one by one, my lord, just to rescue a person who is involved in a sexual assault. This is to be, my lord, it is to be stopped. My lord, it cannot be dragged like that. Lordship, sufficient time has been given. My lord, I oppose, my lord, for any adjournment in this matter. They have availed, my lord, sufficient opportunity. It has heard and opposed.
ನಾಡಿದ್ದಾಗೋದಿಲ್ಲ ಫ್ರೈಡೆ.
ಧಾರವಾಡ ಬೆಂಚಲ್ಲಿ ಇದ್ದಾರಂತೆ. ಗೋಯಿಂಗ್ ಫಾರ್ ಎ ಧಾರವಾಡ ಬೆಂಚ್. So ಸೋಮವಾರ ಇಲ್ಲ ಮಂಗಳವಾರ.
Here, the main matter they have posted, my lord, 6 in that Harvard.
Anyway, I have stated.
Yes.
I have stated.
Before that, my lord, let this matter be finished, my lord.
Additional SPP, na? HCDP. Learned HCDP has submitted and concluded his arguments. Stop. However, a request is made on behalf of respondent number 2.
Respondent number 2.
For short accommodation on the ground that learned senior counsel is not in station. Full stop. Learned senior counsel Shri Harassment Pasha, appearing for the petitioner, would oppose the submission made by the learned counsel for respondent number 2. Full stop. Next, nevertheless, in the interest of justice, release this matter on 9th of October 2023 at 2:30 PM. No further adjournments will be granted at any cost. Yes. Please wait. Please wait.
If I make a submission, one submission. It's been 3 court hearing dates that my matter was not called. That's why I was requesting that I be heard today.
Yes, please wait. Yes.
It's that is gone. If that RMB can go back on my last. May I limit your lordship to the order sheet, the order dated 10/8/2023.
Huh?
With regard to not the kind of a compensation that the PDA is going to offer to the petitioner. Not a submission would also made on behalf of the petitioner also that he would only restrict to the compensation rather not challenging the administration. The difficulty, the difficulty that the commissioner expects. On the PDA side, other than saying that award amount along with an interest of 15% interest the date of the award. Not is the only offer that the PDA can make. But other than that, what we have no other provisions not to make an offer.
This is not passed. Substantial implementation.
The lordship have noted all this. Yeah, they directed us to
Therefore, you can't go back on that one. See, it has been recorded that in terms of KV Jailakshmama and others, nevertheless, it is submitted that in terms of several other decisions which were in fact referred to by learned counsel for the respondent BDA, that under such circumstances, the petitioner will be entitled for allotment of alternative sites or payment of compensation. Learned counsel seeks similar direction. So if that is not possible, then you have to give them alternative lands.
So far as KV Jailakshmama is concerned, the defendant relied upon to say that the acquisition proceedings were quashed and it was declared as lapsed. But that point of the time, I had made a submission before this one to the court. He would be entitled for a compensation or in the alternative and develop site.
Yes.
And that instruction, for that I had taken time to seek instruction.
Yes.
Not insofar as the allotment of the development site, there is a problem for the Bangalore Development Authority because there is no such scheme. So far as RMB second stage is that
It is not as per the scheme, sir. It is not as per the scheme. Scheme was the Berena Vishya. It is not as per the scheme.
40-60 allotment ratio. For that also, that scheme will have to be approved by the state government. As my proposal to allot a site of a developed land to the landowner.
In various other cases where the lands have been utilized without notification, what will you do? Have you not issued directions to give same proportion of land elsewhere?
And they implemented also. It is the value of the land which has been directed to be paid. Yes. Not in that there is a circular of the state government of the 2018, wherein your lordships have referred to it and have disposed of several such cases to give compensation in terms of the 2018 circular. Not where the land is used without acquisition. But that in that circular, reference is made to the to an extent that wherever the land is used, but no compensation is given. But however, at the operative portion of that circular, the state government restricts only to those lands where acquisition is not initiated and compensation is the land is possession of the land is taken. Here it is where possession of the acquisition proceedings are initiated. We are stuck in between. That is why BDA is not in a position to make that offer to the petitioner. Otherwise,
you don't have to make that offer. We will direct. If it is a court order, you will have to implement it. We will direct. Otherwise, you will be in the you will have to face the problem of demolishing those properties and handing over the property to him.
Otherwise, it is not the case. Not that have my certain records, the original records.
See, we understand your difficulty that you will not be able to make certain statement. We will consider that one. We will pass a considered order. After Madi.
Order, but not as a of the offer from the BD note that for which I had taken time. What
We consider and pass orders then. We consider and pass orders.
The ledger extract of the land acquisition. What is but everything is noted, but we don't have those documents to establish those facts. Otherwise, it is not a case as to I have not done anything with the acquisition. Allotments are made in the year 2001, too much prior. I have produced the allotment register also before this one before. That the allotment is made much as early as in 1989. 1989 is an allotment in survey number 33 of groups of the request allotment. What it shows, the recommend what is what the BDA says. An acquisition think that but we have proceeded to form a sites and allot it to, but it is not allotted, it is allotted to the allottees. But definitely the BDA would have not deposited the amount. But unfortunately, we are not able to get that. But under these circumstances, not from what it may consider not of request would be not to interfere with the acquisition proceedings.
That is why you said either give them alternative site. For that one also, if you are unable to accede, then what can we do?
That the government has to permit us. But we had earlier some in some of the cases, but the variance of the allotment of the sites was there with the BDA. In some of the cases, 95% was constantly there are coming under the senior IAS officer. But that committee gave a report that this kind of an allotment by the BDA is not permissible and there is no approval for any of the schemes. And the government came out with this circular that you will have to follow 2018 circular saying that wherever the land is used without
You are admitting the position that you have no records, which means compensation is not paid to them. You have no records to show that you paid compensation. What should this what else can we do now? Then
when they expect those, it is kept in the revenue report.
But now subsequently they have issued an endorsement that it is not there in the revenue deposit also. On the other hand, my lord, their own documents, I will point out, my lords, that they have not even passed the awards because what the entire file was sent in a writ proceedings, my lords, filed in the year 1984, not by this person. The interest between this person and tenant was there, my lords. Forum number 7 litigation came before this honorable court. They came up saying that this land is notified. BDA was also party there. For that purpose, the file has been sent to this court. That is what they are saying. But if the file is sent in the year 1984, my lord, they are not, after that, there are continuous correspondences. I will point out. They are saying that after filing being sent to the litigation, they are not. There is no, without file, they cannot pass award at all. That is their constant document, which is saying that they are sending the file to the litigation.
85 is the disposal. 85 is the disposal of that petition. 87 is when the award is passed, as per the ledger extract. Thereafter the file is not received. Earlier it was sent to, original file was sent to the law section on 10/11/1980.
all right, now tell us what can be done in these circumstances when there is an admitted position. On fact, there are certain admissions. You can't go beyond that one now.
I cannot go beyond.
Yes. No. You give a brief synopsis. I'll pass order.
What you permit, I'll also request the
Huh?
What you permit, I'll just request the member of this court of acts.
Other, you please give a synopsis, chronological events and important aspects regarding this document.
You have sought for compensation when they have not paid, and all those with connections.
All.
Day after tomorrow, my lords.
You give it, yes. Heard, reserved. Yes.
By Monday.
Yes, you can also give your synopsis. Yes.
In spite of the allotee is being there, that has been brought up. Third-party rights and creation.
It's admitted back in similar case, where there was allotment, they filed repetition can be allowed, even after noting that there was allotment. They filed repetition, withdrew the repetition. Therefore, in the order of the became final. Wherein they allotted them to work out the revenue with the BDA, and the land got restored to the landowner. Either they have to come before the sample court, say that we are paying compensation. And they were asking,
We are not
they are not saying that they
I
want.
am not
they-
saying
they
that
do
I
not
am
want
not ready to
compensation.
pay the compensation.
They do not want the consent because they are having the, they are
Misunderstood this way that I am not ready to pay compensation, not I'll have to, I am bound to pay compensation, but I will pay compensation. But Lord, under 1894 Act, there is a provision, there is a mechanism which is provided. No bank at till point of a time has given 15% interest.
If you need a petty prices, if they give that 1 lakh or 2 lakh,
No, not 1 lakh or 2 lakh.
what is the
15% is an interest which is entitled. But that makes a good
adding
sum
that
of money.
15%, it is coming to 5 to 6 lakhs.
My hands
The
are tied.
potentiality of the land is more than.
All right, let us see. Well, let me apply my mind and pass orders. Yes.
Let me have it on the time.
For what?
Waiting.
You can give the synopsis.
Please.
Yes, yes,
Please.
yes.
Number 61. I just like few minutes to.
Sir, please wait, sir. Please come this side. Yes, yes, yes.
Most of them have started withdrawing.
Huh?
Lot of them have withdrawn. But 1% we convinced, 1% we withdrawn. Because we have increased the compensation amount by 10 more lakh. So that they come forward to.
So that is why they are withdrawing, I think.
Only 1% has withdrawn.
Huh?
No, now that I'm telling you, 10 lakh probably it is not that time we have informed them. We have informed them. Not 10 lakh additional, sorry. 1.35. That means 61.1 million.
The WP number 16422 of 2020. Learned Counsel for petition number 4 has filed a memo stating that the petitioner number 4, Shri A. Munegoda, son of Anjinappa, seeks leave of this court to withdraw the writ petition. Stop. Next para. The memo is taken on record subject to all its exceptions. Accordingly, the writ petition stands dismissed insofar as petition number 4 is concerned.
Yes. So far as the main matter is concerned, I have already
Dismissed as withdrawn.
mentioned that my senior is seriously legal or he cannot come to the court if he is not taking follows.
Huh.
You will be taken day after tomorrow.
If tomorrow we have a matter, it may be taken on next week on Tuesday.
Then you let my learned friend argue, let him argue on day after. Any argue.
How many?
Three petitions.
Three writ petitions.
Submission. The arguments of Mr. Satyavish. His argument, you have to just not take. Preliminary notification is issued 10 years before the final notification. That is the main ground of attacking this writ petition. It's 61 and 61.1.
You are also appearing for all the petitioners.
I'm appearing in the third matter.
Ah.
In the third matter, the facts are different. The grounds are slightly different, except one ground. The one ground which is common to all is that there is a circular of the KID which says that agricultural lands, which is WED, which is indicated agricultural land, cannot be acquired without doing a survey. First you have to do a survey, assess the suitability, then do it. That matter is the division bench of this honorable court has also confirmed that the circular is fine. That is the point on, that is the only point on which I am. So insofar as these two petitions, my petition can be treated and no objection in the ballot only the land.
No.
This aspect.
No. That is, we will consider.
It has separate judgment as well.
Yes.
Because the grounds are different. That's all. I just want.
All right. No, if you are ready to argue a matter, you can argue a matter. Yes.
Let's just pass the map of KD. This is the.
One 12961. Yes.
In my melons, the preliminary notification, the 1331 and 28 is issued on 18/3/2022. Final notification is issued on 7/3/2023. Melons, my land melons in this particular map, if my lords were to see, at the bottom, if my lords are seeing, is the parking area and the Barkana. See, parking area.
Parking 2.
Parking 2.
Ah.
15 acres, 25. 15.25 acres. Okay.
Ah.
Ali Nala is at the bottom, abutting the service road.
Yes.
Not just seeing the service road.
Yes.
My land is coming here. So far as the other petitioners are concerned, my lords, their lands are coming in the main industrials. So, my lords, so far, my ground of attack, my lords, is that there should be application of mind as to why that layout, why that particular land is sought to be acquired. Now, the entire land was sought to be acquired in the year 2010. This entire industrial area. Only in so far as certain portions of land, which is including the parking portion of land, the parking aspect, is now sought to be acquired in 2020. Saying that it is required for industrial purpose. No industry can come up next to a nala because of the buffer zone. I'm also seeing the nala.
Yes.
No industry can come up there because of the nala. It has to come up necessarily outside of the nala buffers. So they have now classified it as parking. So let's kindly see, parking is here. It is next to parking is the STP, sewage treatment plant. Red one. Red is the sewage treatment plant. Next to that is sewage treatment plant. No industrial area. Sorry. So next to that, my lords will see, nowhere next to that is an industrial block. Nowhere next to the parking area is an industrial block. Now, if my lords were to see other parking areas, insofar as there are two other parking areas, my lords, at the top of the page. Parking, they have specifically allocated a portion for parking outside of the industrial zone, and all these parking areas, my lords, are next to the industrial.
What that blue color? Not acquired anta padidharalla.
So not acquired is next to the blue color. Blue color is commercial land.
Commercial.
My lord, that is a tank. That is the Veerasandra tank. What is saying? What my instructions are? My lord, subject to what the KID say. My instructions are that is a tank. In fact, this next to my property itself, there is a tank.
Tank madhya road torsidare.
Sorry, that is not that is a Kalnari process.
Allalla. This white color, what they are now showing.
No, that is Nala. That is Nala. That is not road. That is not. So in the main
Adalla, sir. I am talking of this one.
The road, that is a road. Oh, that is
It's a road.
That now laying the road. They are laying the road.
On the tank.
Nala.
Nala is only one path going like this. If the entire blue color is water tank, according to you.
No. Blue color is commercial area.
Commercial area. Water tank. Tank yavadu? Tank yavadu?
All the white portions are the water bodies.
What is this portion of the property?
Howdo?
Not acquired and that by instructions that it's a tank.
Tank.
It is a tank. Water body. So next to that, is the road which is going. This road gives access to the industrial area.
Commercial antandre part of the industrial area. Part of the industrial area. It is the earmark for commercial usage.
Because it is abutting the national highway. Because it is abutting the national highway, they have made. Now the difficulty for KIDB is that insofar as the Nala portion is concerned, they can never get approval for that as commercial. But after acquiring it, KIDB's board regulations would allow KIDB to reclassify areas according to their basis. So that they have the power under the Town and Country Planning Act, insofar as their areas are concerned, there is a specific exclusion in the Town and Country Planning Act under which they can do whatever they want. So today they are acquiring it as park. Why they are acquiring it as parking area? Why they are acquiring it as parking areas? Because of the division bench judgment of this one. Where my lords have held that if it is coming within a particular plan, CDP or some other plan, then interstate between government bodies, there should not be any confusion as regards how the land is to be utilized. I'll show my concept. So on the basis of that, my submission is that this particular area is today earmarked. Originally, it was not a part of the industrial zone. It is today being done because of its proximity to the national highway. Whereas National Highways authorities have in fact acquired a portion of my land. They have paid 4 crores per acre as compensation. What is now being offered by KD?
Where is the notification?
National Highways.
Alla nimdu, the acquisition notification.
Annexure C, page 55.
55.
This one.
The vast extent of land is acquired. Not just 15 acres.
No, not just 15 acres.
15
acres in Birasandra village. Insofar as my village is concerned, I'll show which is mine. Just
This is 2010 ido.
one
You said 2022.
22.
Where is that notification?
142. Page 142.
2022.
But that is the notification under which the entire extent for the that is the notification under which the entire industrial area was under. What notification I just pointed out to my lord, the next one. That is the 2000 under which the entire notification was acquired.
In that one, your land
Mine was not
correct. This is under this 2022 notification. What was the extent of land notified? 118.
118 acres of land, in which my lords, my land comes under the is abutting.
In this one, where is that 118 acres?
My lords, can I put it along with the number sketch? I have a sketch, but I'll correlate it and I'll put it. But anyways, my lords,
ಅದು ನೋಡಿ ಯಾವ್ದು correct ಆಗಿ ಏನು?
Problem is that
now land is in green, and the total extent is yellow is the total 180.
ಕೊಡಿ. You have filed it along with the memo in that writ petition. Sorry.
And very, it is saying there is no need to. This is very.
ಇಲ್ಲೋರ್ಗು ಬರುತ್ತೆ. This entire extent. This entire extent.
Correct. My submission is only that the area which is put for parking, my lords, that area which is put for parking.
See, your submission could have been accepted if it was a separate notification notifying only this 15 acres, 25 guntas as an industrial area, but showing it as a parking place. That is not so.
My lords,
118 acres are acquired, and this portion is earmarked as parking.
My lords, I am on that only. What I am saying is that 118 acres is acquired for industrial.
Yes.
Insofar as parking is concerned, so there my land, small portion of this, out of this 15 acres, my land is only 1 acre and not. But the advantage that I have is that my land is right on the service road. It is on the service road having high commercial potential. Because it has high commercial potential, they want to acquire it because otherwise.
It is not only yours, sir. That is the problem. See, that's why I said, I thought they subsequently notified only this 15 acres, 25 guntas. It is not so. 118 acres are notified and acquired. This forms part of it.
Yes, but what I'm saying
Just because it is in the edge of the layout, facing the national highway, you want that to be given up.
My submission is that. No, I follow what my lord.
Yes.
My submission is not. My submission is that because it is next to a thala, They've designated it as parking area. The question is that if they can, how do they designate something as a parking area if when they originally contemplated the plan of the industrial zone, they want to extend the zone, no difficulty. So I moved on.
Yes.
But correction, not 15, each consider 2 acres. No,
Only 1 acre.
no, totally 2 acres. 2
acres.
totally 2
All.
acres. Out of the 15. No, I said out of the 15 acres, minus 2 acres, coming at this. That's all. No, sir. What my submission is that insofar as this portion is, they are saying it is necessary for the purpose of acquisition, there is an application of made under 2029. Now the difficulty insofar as my case is concerned is that when they issued notice under 29, 29.2 and 29.3, I have not filed objection. My case is that I was not aware, when they came to measure the land, Sthala Parishilane Madak Bandaga, I have seen it, I have objected. They have said, no, it is required for the purpose of acquisition.
Yes.
So that their first contention is that I have not objected, therefore I waived. That method is not correct because my lords can examine the issue independent of whether I waived it.
See, recently I have passed an order. Similar contentions were raised. I have rejected that contention. See, if it is forming a part of the comprehensive industrial area, and merely because it forms it is in the edge of the layout, and you are seeking exclusion only for on that grounds, it will not be permitted.
I see. So that is my first submission.
Yes.
Insofar as the other submissions are, may I just request my lords, can take up the matter when my lords are taking up the matter.
That is why I am requesting the learned councils, please accept the offer that is being made. That will be beneficial to all of you. If you don't want to accept, it is up to you. The court cannot force you.
My lords, insofar as my case is concerned, the
But
difficulty is that-
see, you should also understand if there is genuinely good ground, there is something there to be considered, we can consider. Otherwise, if these kind of these are the kind of grounds that are raised, I don't think you will be able to succeed.
My lords, then
It's up to you.
only one aspect. They served me a notice for award, in which, my lords, the proceedings which are enclosed are they are determined insofar as the compensation which is being determined. What is being determined for these portions, that is the ಮೇಲ್ಗಡೆ portion ಏನಿದೆಯಲ್ಲ, the same is being determined for this portion also.
ಅಲ್ಲ ಬೇಡ, separate ಆಗಿ ಆಫರ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಈಗ.
ಇಲ್ಲ.
Why don't you consider that one?
But the difficulty, they are not taking into consideration that we are right next to the gate. They are not taking that into consideration. They are giving
ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ ಹಂಗೆ? ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
reference this, take instruction.
Yes. I think the offer that is being made now is quite attractive. Madam, no further adjournments will be granted. I will take it. Release this matter on 10th of October 2023 at 2:30 PM. Yes. Who is appearing in this matter? Yes, what is this matter about?
Yeah. He says he has filed some application in the US trademark office for registration some his invention. There is the international search report which has been given to him. He finds some past results. Now you want to prosecute the US trademark office government of US in India. So section 86(2) of the CPC.
What is CPC?
What are the circumstances in which their consent can be given?
I will read mine.
There's no time. I just want to know what the matter is about. I can't hear you now.
86 suits against foreign rulers, ambassadors and envoys. No foreign state may be sued in any court otherwise competent to try the suit except with the consent of the central government certified in writing by government. Candidate can do 86(2) minutes.
Such consent may be given with respect to a specified suit or to several specified suits or with respect to all suits of any specified class or classes and may specify in the case of any suit or class suits, the court in which the foreign state may be sued, but it shall not be given unless it appears to the central government that the foreign state has instituted a suit in the court against the person during the suit, deciding to sue it, or by itself or another trades within the local limits of jurisdiction of the court, or is in possession of human property situated within those limits and is to be sued with reference to such property or for the money charged thereon, or as expressly or impliedly waived the privilege according to it by its. These are the four situations where we can consider the request. These are the four situations. And apart from that, he says there is a patent cooperation treaty. But all any issues are concerned, I can get the instruction. Now we are arrayed, Minister of Extra Party. They don't do it the subject. Subject is dealt with Minister of Commerce and Industries, Department of Industries and Promotion and Internal Trade. He has to make them as a party so that we can get some instructions. We got any alleged violation, what is the remedy available? Whether we can use some diplomatic channel to assist him, something can be done. Being a citizen, we can make out whatever the diplomatic channel use if possible. That I can get the instruction if we arrange the Ministry of Commerce and Industries and the department in the party, they will give instruction. Then I can make assisting whatever next is possible.
But how will that department deal directly with the?
They don't deal with actually in US. There is the Sovereign Immunity Act is there, 1970, US is. As far as India is concerned, we don't have such enactment, but Section 86 only alone deals with that. Now they are exempted from prosecution unless you give permission. So it will have other ramifications. Situations have been elucidated in Section 86(2) of the CPC itself. If he finds out any of these things, suddenly the department will consider. Moreover, now he has to.
Unless it appears to the central government that the foreign state has instituted a suit in the court against the person desiring to sue.
They have not.
By itself.
Yes.
Or any other trades with the local limits of the jurisdiction of the court. No. The foreign state is in possession of immovable property. No. The foreign state has expressly or impliedly waived the privilege accorded to it by this section. No. These are the only.
We don't have any immunity act. Sovereign Immunity Act is not is there. Only Section 86 to take care of. Suppose there is a consulate general of US. If they get into some property here on lease or something, such cases, whatever, that's what they have said. If he is occupying that, we can give. Such things are taken care of. If this is the case where anyone is like Indian office is going to be prosecuted. The patent cooperation treaty matters. Anybody can. It's only facilitating a person to file an application anywhere in the world. So there are some procedures. Foreigners will come and file in our trademarks office. If any order is passed, they will challenge people the jurisdiction of this particular high court or elsewhere. He has to prosecute there only. Yes, sir. Wrongly is coming and saying that peaceful. He has issued other two more petition suits without there being any complaint of this requirement.
Yes, filed two more.
Suits. Yeah, I have filed suits
No.
and the replacements.
I don't have two more suits.
There
is no suit active.
Yes,
There is no suits active right now.
This is the first he has to satisfy, and also if he is willing, he has to array the Commerce Ministry so that I can get some instruction.
Now, if I may speak. So United States Patent and Trademark.
Please understand, sir. I don't have time now. Please understand. I wanted to know what is the case about. He is now trying to help you by saying if at least if that department which deals with the trademarks, commerce, if they have got some information or if they have dealt with some case like this, if they at least are arrayed as parties, he can get some information from them.
This Honorable Court has already issued orders for a hearing according to the CPC Section 86.
Now, according to CPC section 86 of 1, I need their consent letter and I have given all.
Correct. That can be given only under the circumstances mentioned there.
I am referring to the final orders dated 6/2/2023, Annexure B. These are the orders issued by this honorable court because the respondent is legal and treaties division.
Correct.
And when I had approached the ministry for getting this consent letter, they had told me that because this has got to do with breach of patent cooperation treaty, and I have all the documented evidence and it is published by World Intellectual Property Organization International Bureau, they suggested that I speak to the respondent, which is the legal and treaties division. So United States Patent and Trademark Office, for my TCT international application, which is filed under the provisions of patent cooperation treaty, where patent cooperation treaty recognizes me by Article 9 of 1 of the patent cooperation treaty. So I am the applicant and the sole inventor for the international application that I have filed. So while issuing the international search report in the capacity of international search authority, United States Patent and Trademark Office breaches PCT articles 18 of 2 and 19 of 1. I have full documented evidence and this has been published by International Bureau, World Intellectual Property.
Then you will have to challenge it in the United States of America, not here.
No, you know.
That is the submission.
Jurisdiction.
The only way you can approach this court in respect of a foreign state is under section 86.
Under sections
86 has got a limited scope. That is what he is trying to say. It is clear from the provision itself. You can't go beyond that one. Even this court cannot direct the central government to do something which is beyond the scope of section 86.
It is within the scope of section 86.
Let us see.
So I need under 30 minutes for hearing. And I need tomorrow, if you accommodate under 30 minutes, tomorrow you are at 2:30. I want to present documented evidence.
You please file a statement of objections. You file a statement of objections.
Now, one
Now you have also said, I have also said that if he doesn't want to do that, we can't force him.
Trial court is ready to initiate.
You please file statement of objection. The respondent, central government, is directed to file statement of objections within a period of 2 weeks from today. Yes. Yes. I'm not going to fix a date for after vacation.
Evidence.
Yes.
I need under 30 minutes. Could I be heard?
Not now. Listed next week. Wherever interim orders have to be extended, you please mention it will be extended.
My lord.
Two weeks.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ 50. ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ಅದೇ 55 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ಫೈನಲ್ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು
ಅಲ್ಲ ಸರ್ ಅರ್ಲಿಯರಿಂಗ್ ಕಷ್ಟಪಟ್ಟು ತರಿಸಿದ್ದೇವೆ ಒಂದ್ ಡೇಟ್ ಯಾವ ತರ ಕೊಡಿ 15 ದಿನ ಬಿಟ್ಟು ಬೇಕಾದ್ರೂ ಡೇಟ್ ಕೊಡಿ 1 ತಿಂಗಳು ಬಿಟ್ಟು ಬೇಕಾದ್ರೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್ ಸರ್ ಅಲ್ಲ ಸರ್ ಮತ್ತೆ ಅರ್ಲಿಯರಿಂಗ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ ಅಲ್ಲ ಈಗ ಐ ಹಾಕಿ ಬಂದಿದೆ ಮತ್ತೊಂದ್ಸರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಐ ಹಾಕ್ಬೇಕಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮತ್ತೊಂದು ಐನಾ ಅದ್ ಹೇಳಿ ಸರ್ ಹಂಗ್ ಬೇಡ ಅಲ್ಲ ಸರ್ ಈಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸಾಹೇಬ್ರು ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೆಲೆ ಎಲ್ಲಿದೆ ಹೇಳಿ ನಾ ಸಾಹೇಬ್ರನ್ನೇ ಕೇಳ್ತೇನೆ
ಸರ್ ನಿಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅನ್ನೋದಕ್ಕೆ ಬೆಲೆ ಎಲ್ಲಿದೆ? ಅದು ಬೇರೆ ವಿಷಯ. ನಂಗೆ ರೀಚ್ ಆಗುತ್ತೋ ಬಿಡುತ್ತೆ ಅಲ್ಲ ಸರ್, ರೀಚ್ ಆಗುತ್ತೋ ಬಿಡುತ್ತೋ ಬೇರೆ ವಿಷಯ. ಸಾಹೇಬ್ರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರು, ಅದಕ್ಕೆ ಬೆಲೆ ಇಲ್ಲ ಹಂಗಿದ್ರೆ. ಬೇಡ ಸರ್, ಒಂದ್ 15 ದಿನ ಬಿಟ್ಕೊಡಿ ನನಗೆ ಒಂದು ಡೇಟು. 15 ದಿನ ಬಿಟ್ಕೊಡಿ ನನಗೊಂದು ಡೇಟ್. ಯಾರು ಒಂದು ಡೇಟ್, ಯಾರು ಒಂದು ಡೇಟ್, ನಿಮ್ಗೆ ಯಾರು ಒಂದು ಡೇಟ್. ಅಲ್ಲ ಸರ್, ಸಾಹೇಬ್ರು ಹೇಳೋದಕ್ಕೆ ನಮ್ಗೆ ಬೆಲೆ ಬೇಕು ಅಂತಾನೆ. ಸಾಹೇಬ್ರ ಮಾತು ಉಳಿಬೇಕು, ಮಾತು ಉಳಿಬೇಕು. ಯಾವತ್ತರ ಉಳಿದೆ, ಯಾವತ್ತಿಗ್ರ ಉಳಿದ. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, ಅವಾಗ ಏನ್ ಗೊತ್ತಾ, ನೀವು ಸ್ವಲ್ಪ ದಿನ ಆದ್ಮೇಲೆ ಒಂದ್ ಯಾಕೆ ಆ ಸರ್ಕ್ಯುಲರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತೇವೆ. ಬರೋದಿಲ್ಲ, ಬರಲ್ಲ ಅಷ್ಟೇ, ಕೇಸ್ ಬರಲ್ಲ, ಸರ್ಕ್ಯುಲರ್ ಬರಲ್ಲ. ಇಷ್ಟೇ ಸರ್ ಹೇಳ್ತೀನಿ. ಈಗ ನಮ್ಗೆ ಬರ್ತದೆ ಹೇಳಿ, ಬರ್ತದೆ ಇಲ್ಲ. ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟ್ರು ಒಟ್ಟು ಕಷ್ಟಪಟ್ಟು ತರಿಸಿದ್ದೇವೆ AFR ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ. ಈಗ ಅವ್ರು ಒಂದ್ಸರಿ ರೀಚ್ ಆಗದೆ ಇದ್ರೆ ನಾವು ಡೇಟ್ ಕೊಡಲ್ಲ ಅಂತ. ಇದು ತಾಪತ್ರೆ. ಈ ಡೇಟ್ ಕೊಡದೆ ಸಾಹೇಬ್ರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿ ಎದ್ದು ಹೋದ್ರು. ಹಾಕ್ಬಿಡಿ.